Different one.
So with deep apology, Lordship, although it's a top of the list matter, Lordship, I'd like to mention item number 4 and 5, Your Lordship.
What happened?
Lordship, actually, due to some unavoidable difficulty, Lordship, we could not prepare the case, Your Lordship.
Okay.
Maybe after vacation, Lordship, we will.
And counsel for the respondents has circulated an adjournment slip with the request to adjourn the matters post vacation, post puja vacation.
Yes, Lord.
Counsel for the appellant does not object, thus list after the ensuing puja vacation.
Much obliged.
Obligation.
May I please, Your Lordship?
Yes.
Lordship, I am representing the appellant in this item 16 and 17. Lordship.
16, 17.
16 and 17. Lordship.
Yes.
So, my lord, I am just praying for a short day, Your Lordship, because we have to file a certain document as accession affidavit. I have informed earlier also to my learned friends also. Your
I know.
Lordship. Any date, my lord, short date after the vacation.
For the appellants, submit that some more pleadings are required to be filed on behalf of the appellant, and thus short opportunity may be given for this purpose. Ms. Saiwala, Senior Advocate Mr. Saiwala, representing the state of Manipur, does not object. The private respondent, private respondent does not
representing
state of Manipur is does not object to the prayer so made. Thus, list the matters after, or maybe fix a date
Yes, my lord.
on 29th, 30th November.
Deep obliged.
Obliged.
Well, you could have addressed the court through VC. We are having virtual hybrid mode
Yes.
ever since
Yes,
the process started
Will be
in
obliged.
COVID. We never stopped it.
Yes.
Yes.
Deep obliged.
At least we can say that Guwahati High Court has been adopting that hybrid hearing mode.
Deep obliged.
Yes.
Never, it was never discontinued.
Yes.
That's right, Saiwala sir?
Yes, yes, madam.
Yes.
Daily list for orders item 11.
Yes.
May it please your lordship.
What has happened to the order whereby you were given the opportunity regarding the boundary wall? Ms. Saiwala, you are not there in this case. Item number 11.
11 years. Sorry, madam. Oh, 11.
Who is there? No one. All right. None present.
I'm there. I'm there. Thanks.
Rajib, Mr. SK made his on his way.
All right. Pass over.
First one. Well, for today, all.
Right now, we'll take it up in the second round.
Madam.
They had to tell us about the compliance of that order.
Madam.
A long time has gone by. He has to make a statement.
Item number 12.
Yes, Mr. Nath.
But for the respondent, I entered appearance in the matter today. Lordship, pursuant to Lordship's order passing the writ appeal, they have undertaken a process of demarcation, my lord. But the process is not complete because in the meantime, they found that within that particular 45 bigha, there is a building standing. And that particular building, the person concern has shown documents, my lord, and the process is undergoing. Lordship may give us some.
All right. Whatever compliance report you want to place,
We will place it.
Mr. Nath
We will place it.
puts in appearance on behalf of the contemners, respondent contemners. He prays for and is granted 4 weeks time to file compliance affidavit.
Well,
List up 4 weeks.
Okay.
Item number 13.
Pass over.
Item number 14.
Please, your lordship. Kindly the matter will be passed over for the timing, your lordship. 13 and 14.
Pass over.
Item number 15.
Lordship, I will pass over the matter for time being.
Pass. Call out item number 18 also. Yes.
Item 18.
What is it, Ms. Ganguly?
That was, this is the challenge to that part of the amendment of the schedule regarding EWS. Lordship, if you take it up on, because this will require some time. for the-
After vacation, Lordship.
As jointly paid list after the ensuing puja vacation.
Highly honored.
Problem.
Supplementary list, item 19.
So we have placed all the records yesterday, Lordship.
Yes. What do you say, Ms. Kalita?
Lordship.
There was one loud thinking on our part. We had suggested that, can you keep him under observation for 6 months or so?
It
But it's
was
totally
too-
undesirable.
It was too long, Lordship. Already he was given ample opportunity.
Okay,
Ample opportunity was given to him.
very well. All right, Ms.
And
Kalita.
right now, 2, 3 cases are pending here.
Okay, still is litigation, some litigations are there?
Yes, yes, Lordship. When the council wanted to take action, he came before that. Council does not have the competence.
So Lordship, I have gone through this letter. I have got the instructions about this letter. We have prepared a small reply to this, Lordship.
You file it, then for the present, we'll keep the single judge's judgment in abeyance. for the presence.
Lordship, may kindly place, let me place couple of things, Lordship.
All right, do that.
Lordship,
Ms. Kalita, in any event, you see, sometimes we have to keep the legality
absolutely,
stricto sensu
absolutely.
aside,
No,
so as to deal with the practicalities of the
I
situation.
fully agree.
We can't turn a Nelson's eye to anything and everything.
Lordship, I fully agree, but like Lordship, sequence of events, how it has happened,
Yes.
Lordship, I'm sure Lordship will be able to convince your Lordship.
We'll hear you. We'll hear you. Let
Lordship,
it come up after puja break then. For the timing, we'll keep the single judge's
no,
judgment.
he has
in.
already joined, Lordship.
Maybe, it doesn't matter.
He has already joined, Lordship, may kindly
Then
hear.
let him enjoy the holidays then.
No, only couple of things, Lordship, about the letter, Lordship, I'll just point it out.
Mm,
About the letter, Lordship, what they have written.
mm.
And for one information, Lordship, as far as the litigations which are pending before this honorable
Mm.
court,
Mm.
the stay orders were passed long time back. No vacation of stay has been. I mean,
We will,
filed with this-
we'll connect all those files with this writ appeal.
Yeah,
Lord, hear them together.
Now,
No, Lordship,
broader issue regarding who has the control, whether the
Then-
state government or the council.
No, Lordship, only about two things, Lordship. This letter that has been placed, Lordship,
Mm,
that at the bottom paragraph, Lordship, what has been written is that in the light of the above, the Karbi Anglong Autonomous Council also desires the government may like to initiate departmental proceedings against NK Sharma, both instances of suspension by so and so and so and so. Lordship, as far as suspension of this 16/12/2019 year, Lordship,
Hmm.
16/12/2019, Lordship, we have approached the honorable court.
mm.
Initially, we got a stay, Lordship. Then, Lordship, then what? There was they have revoked that suspension order.
Obviously,
They have
with time they have to do it.
No,
Ajay Chaudhary.
No, they have revoked the suspension order and the matter was disposed of finally. Lordship.
Yes, yes.
But
We
it was-
understand they have to, they
No,
can't,
They haven't come
can't
before.
continue with the
Lordship,
suspension.
they have not come before this honorable court filing an appeal, Your Lordship. Now they would want to take action in that, the suspension order again. And secondly, Lordship, that suspension
Kalita,
order.
it's not a matter of suspension simpliciter. There are too many complexities to this
No, Lordship,
continued presence.
Lordship, those complexities happened much before, Lordship. Now new issues, there are no new issues, Lordship. I'll convince you, there are no new issues at all, Lordship.
Ask
He
your client
has
to
been
be.
working, and Lordship, I kindly see, kindly appreciate one thing, Lordship.
Mm.
The case laws that, Lordship, that my learned friend has placed, I would like to place the case laws, Lordship.
All right.
I mean, like Lordship is, in my humble opinion, Lordship is basically trying to see how the situation can be solved and the proper atmosphere come to the college, Lordship. But in this situation, Lordship, what is happening in the case laws that they have placed there, Lordship, that whether, Lordship, I mean, if the statute bars it itself,
Mm.
if the statute itself bars that there cannot be a transfer, there cannot be any attachment, that in that situation, what will be the steps the state can take? The state can take always steps, Lordship. State can take steps of giving him a show cause notice. If they are not satisfied, he can be released, he can be
The
terminated.
moment they give a show cause notice, there are two pleas. KAC has no jurisdiction, state has no
So
jurisdiction.
those
That is
matters,
a catch 22
no, those
situation.
matters are pending before this court. They have not come before this court filing an.
We will call them here
No,
and
Lordship,
decide them together.
Lordship,
So one forum of appeal will be lost.
the Lordship,
for the
that case, no, Lordship, that maybe I'll just distinguish this case, Lordship.
Sure, sure. The Punjab judgment.
No, Lordship, that Union of India and others was a Jonathan Devnath and another, wherein Lordship, a transfer was allowed. Paragraphs 9 and 14, Lordship, that will be relevant. The hearing, actually, the argument was forwarded that there was a situation which has happened, that because of that, show cause notice may not be given and he can be transferred. So here, Lordship, the situation is different here, Lordship. Page 9 here, Lordship. Sorry,
Yes.
page 249, paragraph 9 here, Lordship.
Not completely fine.
Yes, please.
May I read it, Lordship?
Yes, sure.
A bare reading of Rule 37 shows that officials of the department are liable to be transferred to any part of India unless it is expressly ordered otherwise for any particular class or classes of officials. Transfers were not to be ordered except when advisable in the interest of public service. The transfers can be made subject to conditions laid down in FR 15 and 22. So here, Lordship, FR 37, FR 15 is applicable there. This allows the transfer can be made. If there is a situation arises, he can be transferred. The transfers can, the applicant, the appellant, as indicated as to why and under what circumstances transfers were thought proper in the interest of public service. The High Court, while exercising the power under Article 226 and 227 of the Constitution of India, had gone into the question as to whether transfers was in the interest of public service. That would essentially require factual adjudication and invariably depend upon the particular facts and circumstances of the case concerned. No government servant or employee of a public undertaking has any legal right to be posted forever at any one particular place or place of his choice, since the transfer of a particular employee appointed to the class or category of transferable post of one place to another is not only an incident but a condition of service necessary to public interest and efficiency in the public administration. Unless an order of transfer is shown to be an outcome of bona fide exercise or stated in violation of statutory provisions prohibiting such transfer. So here, Lordship, the statutory provision is that you cannot transfer him. It's a single cadet post. You cannot take him to an ex-cadet post, Lordship. So it's a statutory violation is apparent here, Lordship. In this case, Lordship, because statute allowed that. Statute allows, FRS allows it. So this honorable Supreme Court has taken an opinion in 14, paragraph 14. They have taken an opinion because the allegations are quite serious and like his continuance may not be correct there. So in that situation, since the transfer was allowed there under the statute, but in this case, the statute doesn't allow it. When statute doesn't allow transfer, Lordship, I totally appreciate that equity is one aspect Lordship has to look into. But when the statute doesn't allow it, Lordship, in these circumstances, and Lordship, these incidents, which I can come with the chronological sequence, Lordship, these incidents happened long time back, Lordship. As far as couple of incidents they have, they have cited before your Lordship at present. As far as like vehicle is concerned, I have those papers, Lordship. Those vehicles, the vehicle was bought in the name of different college, Lordship. It was not like that. It was only before the registration authority, when they asked for a name, he inadvertently given that his name. When a complaint came from there, an FIR was lost in that case, Lordship. And FIR, Lordship was, the FIR was filed later on. They're saying that there was no inconsistencies, there is no wrong in that. FIR is also, that copy of FIR is also with me, Lordship. And there was no other incidents happened here, Lordship, after that, Lordship. The incidents, Lordship, happened in 2014. Now they are carrying the grudge till now, Lordship. And Lordship, what I can do, Lordship, if an illegal order is passed, I'll have to approach this honorable court.
There is no dispute that. No dispute that you will have to approach
Lordship,
the court.
after 2014, no incident happened, Lordship. They cannot cite any incident, Lordship.
That's right.
I mean, now this case, Lordship, they want to reopen this suspension order, which has been revoked. by themselves. And thereafter that this honorable court has disposed of the matter, your lordship, when they put a notification saying that they are revoking the suspension order. So in that circumstance, lordship, I am working there. And lordship, as far as NAC and all these things, lordship, I have explained, I have replied to, I have explanations to that, lordship. Till 2005, there was no NAC accreditation. Lordship, what are the things I have done, lordship? I have explained. I mean, there is nothing. I mean, lordship, I have joined there in 2004 as a lecturer of chemistry, lordship. I have been working there peacefully. There was no problem at all. When I was appointed as by a PSC, under an advertisement, when I joined as a principal, the issue cropped in, lordship, because there are another person there who is a local person. He wanted to be a principal. That is the main cause here, lordship. Then some unknown persons have filed an PIL. The PIL was thrown by this honorable court because there was in the same day only PIL was dismissed. Then they came up with suspension order where there was no ground. I came to this honorable court. Honorable court stayed it long time back in 2014. No vacation of stay has been filed by the state till now. Then what they have done, they have released me again. I came before this honorable court. Honorable court has given me a stay. All these grounds, lordship, whatever the grounds about that situation is not.
What about non-joining despite the pertinent
Lordship,
direction of this?
I have answers to this, lordship. When lordship, this issue when non-joining happened, your lordship, that after the order, in initial order, lordship, then
Where is that order? Can we have a look at the order?
I'll
Page 87.
in the additional affidavit, lordship.
Page 128,
128.
paragraph 10. In the light of forthcoming Durga Puja festival, the court is inclined to provide that in the event the petitioner makes a representation to the respondent number 1 for granting him some time to make arrangement to join in his place of posting, the respondent number 1 shall grant 14 days time to the petitioner to join his place of posting without any coercive action till such time. So 14 days
Lordship.
handle was given to him.
Let him explain.
So, lordship, after this order was passed, lordship, I could not join immediately. Lordship, I could not join immediately. Then the interim order was passed on 8/10/2021.
And when did you join?
Then the lordship, I joined after the passing of the final order only. In between, lordship, something has happened that I would like to place before lordship.
Sure.
In between, lordship, what has happened, a show cause notice was given to me, lordship, on 25/5/2022. After 5 months, I have been given a show cause notice, lordship.
Yes.
Now that show cause notice, lordship, reply for suspension. Then I have replied to that show cause notice on immediately, lordship, on 38/5/2022. Then, lordship, I requested for inspection of documents on 27/6/2000.
What was the requirement? We don't understand. The order of this court was clear. Is your client educated, we presume?
The lordship.
The order was very clear. You were to join in 15 days. Why this rank and discipline? By a man who claims to a very strict disciplinarian.
No,
Why
lordship,
this indiscipline?
lordship, the matter was before this honorable.
Whatever, this court made it clear
And
that the stay is being granted subject to the condition that you will join in 14 days.
No,
A
lordship,
principal doesn't join for 1.5 years. What is the state of
lordship, they have come up with a departmental proceeding. I was attending
after
to
5
that.
months?
I am attending to that, lordship.
After 5 months.
Lordship may kindly appreciate their conduct also, lordship. What has happened, lordship, after that? I have sought for documents.
We
They
are
have
asking
given
you what is the status in between that period of 5 months?
the 5
He has
months.
made it a prestige issue. I will not join, come what may.
No,
That is what the state is.
that was
State of affairs. That's what.
in my humble service.
On
that
this precise reason, we are not inclined to grant your claim.
Lordship may kindly appreciate one thing. Departmental proceeding was started. Then I asked for certain documents. They were not
Please.
responsive at all, lordship. They were not responsive at all.
Mr. Kalita, he is after all a public servant. And if a public servant flouts orders of this court, he cannot claim any equitable relief. We are very sure of it.
No, lordship,
Absolutely certain in our mind.
no, lordship, lordship,
This is blatant flouting of this court's order.
well, my instructions, lordship, is that, lordship, what has happened is that, lordship, this principal, when he joined there, after that, lordship, there was a student leader there. There was some problem. about this student.
That is
letter.
what
Then-
they are
no,
saying.
Lordship, no, Lordship.
That is
Lordship,
what
I
they are
understand.
saying all along.
That student later on came to was inside the jail. He was a rapist, Your Lordship. Lordship.
Father, what
Lordship,
those things?
I do not want to all tell all these things.
Question here is Ms. Kalita.
Lordship, one thing, Lordship may kindly appreciate
Yes.
that in 2014, what happened? These students and on instigation of certain other people, Lordship, he was bashed up inside his chamber. He was very badly beaten,
That
and
we haven't- that we have seen.
he was there in Lordship in GNRC for 15 days,
No.
and his brain got some problems and all. He has some neurological problem developed thereon. So after this, Lordship, he was having some medical problems, so that has been told to me, Lordship.
He
That
will
is-
get a better redressal for the medical
that-
problems in Guwahati.
So this, Lordship, this period,
That
Lordship,
opportunity is given.
Lordship, only for this period, Lordship, I mean, like, he may not be, Lordship.
This period means it's a 1.5 years period. sir.
That Lordship, that Showcase notice was given, Lordship. I was
Oh,
responding
showcase
to
notice
that.
was after 5 months. sir.
I was responding to this, Lordship. I was
Admit
responding
it
to
still.
this.
Highly obliged, Lordship.
We'll pass a reasoned order.
Deeply obliged.
Item number 20.
Yes.
Lordship, herein the petitioner had taken a loan. Actually, the loan he had taken in 2012 and it was extended in 2017.
Hmm.
Lordship, till 2019, the business was going on smoothly. After that, some problems with the lockdown. And subsequently, his assets were declared as NPA on 31/5/2021. And also subsequently, they were auctioned off, even after best efforts of the petitioner. But now what has happened, that there were two properties, Schedule A property and Schedule B property.
Hmm.
Lordship, if you have a look at page 53, Lord, after the auctioning of Schedule A property,
Hmm.
the total loan was of 1 crore 51 lakh.
Hmm.
And the property was auctioned off for an amount of rupees 3 crore 76 lakhs. Like that. Your
Yes.
Lordship. Lordship, even after that, a surplus of rupees 2 crore 25 lakhs has remained in the
Okay.
account of the petitioner. Now, Lordship, subsequently, they issued a notice on
Hmm.
7/8/2023
Hmm.
for vacation of Schedule A property. Now,
The
because
other property,
Lordship,
the other property or the first one?
the first property, Schedule A property. Lordship.
Okay.
No, but it could not be done because Lordship, there were some demarcation problems. As per our knowledge, the building which has been stated in Schedule A property,
Hmm.
that does not fall within the plot of land, which is mentioned in the Schedule A property. Now, subsequently, it could not be done, so that process had to be halted.
Hmm.
Now, again, Lordship, on 9/10/2020, they issued a subsequent notice, second notice,
Hmm.
for vacation of the Schedule A and the Schedule B property.
Hmm.
The Lordship, Schedule B property has not been auctioned, and there is no need for it to be auctioned. Lordship, by the auctioning of a Schedule A property, the loan has been extinguished.
But if they are not able to take possession, what is the point? What is the point in extinction of the loan?
Lordship, the
You,
thing-
you ensure that the vacant possession is given? Then we'll accept your prayer.
No, Lordship, they had come for taking possession. But
Yes.
Possession could not be done because of some demarcation problems. Today
So
also,
that,
Lordship,
who is responsible for that? You gave the property as a mortgage. And if there was something underlying issue with the property, who is responsible? Come out with a clean hand, say that I am providing possession of the first property, and then we'll ask the bank
no, Lordship,
to hold back.
Lordship, if the circle officers and they come and they do a demarcation, then we have no objection. They may take the first Schedule A property. But Lordship,
Absolutely
Schedule
no.
B property
Let
is
the,
Lordship-
let the second property be auctioned, he will get the first property release immediately. That is the only answer. This is hide and seek. Apparently.
Lordship, the schedule,
You see, this is a very common feature, gentlemen,
Right.
that keep something in hand. If the property is auctioned, we can always take this technical objection.
Lordship, the property Schedule A property has already been auctioned, Lordship.
Yes, so they will auction the Schedule B also. They'll start with that because they are not able to get possession of that property. They will have to return the money to the auction purchaser.
No, Lordship, today they are coming and they are trying to take possession. The problem, Lordship, is with the demarcation. That's a authority.
You resolve that problem.
No, he has no locus standi. The petitioner firm is not the owner of the property. The owners of the property have not come before.
Of the Schedule B property.
Neither Schedule A nor
Lordship,
Schedule B.
they are the partners, Lordship.
Page 59, Manoj.
Oh.
Page 59, the Deputy Commissioner's order, Manoj.
Hmm.
Lordship will see schedule of the properties.
Hmm.
1 and 2, Manoj. The owner of Schedule A property is Mitra Dev Mahanta. And Schedule B property is at serial number 2,
Hmm.
Manas Chaudhary. Neither Mitra
Schedule B is Manas Chaudhary.
Manas Chaudhary.
Where is
neither,
it mentioned?
Serial number 2, my lord, all that part.
Yes, all the part and problem. Yes.
This part, in the name of Manas Chaudhary, neither Mitradev Mahato nor Manas Chaudhary are before your lordships.
No.
Before your lordships is the partnership firm of two other persons, my lord.
Lordship,
Yes.
they have
They may be
given the,
family members, but this is not, they are no
They have
locus standi, my lord. to
they have been
No,
given the
no.
authority. Lordship.
Moreover is Abhijit, HM Construction,
Yes.
Lordship.
including Abhijit, Celian, Mitra Dev Manta and Manas Chaudhary.
Manas
Manas Chaudhary is
he is a
there.
partner of the firm, Lordship.
He is a partner,
And
but
Man-
he has not filed the
Mitra
writ
Dev
petition.
Mahanta is the father of Abhijit
He has
Vallabh
not
Mahanta,
filed.
Lordship.
No, but it's a firm which is filed.
It's a firm.
So
that
that objection is not sustainable. But yes, regarding that part, that the position is not being
And
handed over.
demarcation. And as far as demarcation, my lord, he went to the DRT. He obtained an interim stay order. He did not deposit the conditional deposit. The essay was dismissed for non-prosecution.
Why you are not able to,
Of demarcation.
why you are not able to take possession? What is the reason?
Because when we went for the first time, after, no, this has happened under the orders of this court. I may place that order of the court on record. No?
What is the order? Let us.
No, this was passed in writ petition by the learned single judge, and they are aware of this this order. They have filed this order also, my lord.
Let's see. They filed it on record.
Yes, my lord. Page
Where is it?
55, not the order. They have mentioned the notice, my lord, which says about the order, my lord. Page 55, my lord.
Yes. The bank approached this court.
Yes, the bank approved this court, my lord, and the bank, my lord, this court, my lord, the learned single judge directed that the physical position be taken
Hmm.
of these properties, my lord. Because there was some delay, my
For
lord, that-
police help.
Yes, for police assistance under section 14, my lord.
So then why that police assistance is
Because
not
when
being provided or what?
No, after this court's order, my lord, the deputy commissioner provided the police help. Then they raised disputes of demarcation for the first time, my lord. After
The
the
dispute has been raised by them.
by them, my lord.
Where? Where?
Before the magistrate, my lord. And it's also here at para number 18, para 19 of this.
All right.
Lordship,
Nothing remains, my lord, for them to do.
before the magistrate,
All right, in this court, let us
Verbally,
see.
before you
Lordship,
take a seat,
verbally,
they even
you
try
are-
to-
you are-
something.
You are not allowed to play hide and seek, gentlemen. This is public money.
But if he is the
Lordship-
mortgager, how can you say it is not demarcated, my lord? How can
Yes.
he be permitted
All
to
right.
go hot and cold?
Do you want to take instructions for giving peaceful possession to the bank for the Schedule A? Then we'll interfere. Otherwise, no interference.
Lordship, some time may be given, Lordship.
Tomorrow,
Lordship, but today they are coming for taking. over.
they will have to. They will have to take the instruction, come back to, come at 12:30.
Today, Lordship.
Yes,
Lordship, yes.
all right.
Yes.
After the board is over,
Lordship,
first round, come back. It'll take 2 minutes, not more.
Lordship,
Come back in the second round.
Lordship. All right.
Pass over for the first round, yes.
Passed over matter, item 11.
Yes, Ms. Mehdi.
Yes.
What is your instruction? We have given you a particular direction.
Yes, my lord.
That order, we suppose, has not been carried further,
My lord,
stands as such.
my lord, there is no wall from now. There is no wall from their side. My lord. There is an army wall, my lord. Army, we have wall in that particular area, my lord.
We have,
We have wall, my lord. They
you have put up a wall.
already we had, my lord.
So let them put up a wall then. What is the
My
problem?
lord, they have no wall. They dismantled, my lord. That was
Now
dismantled.
we had given you that suggestion that let them put up a wall.
My lord, the officer is here, my lord. He will assist, my lord. He also assist.
Hmm?
My lord, officer is here, my lord. He will assist, my lord.
We need a statement from the council. We are not bothered about the officer.
Yes, ma'am. Yes. My lord, the wall is there, my lord. Already wall, they not required, my lord. There's no wall is.
Oh, that is your stand. You are not going to allow.
Yes.
Okay, we'll decide your right appeal then. Very well. Argue on merits.
Yes, ma'am.
All right. Argue on merits. Very well.
My lord,
We'll take note of this fact that you have given an emphatic statement that you are not ready to the landowner constructing a wall on his land.
my lord,
Argue,
that is
come on.
dismantled, my lord. Already dismantled, man. As per order of the honorable court, it was dismantled, my lord. So we have.
We had made an observation
Yes, ma'am.
that are you prepared to allow them to reconstruct it? On that, your stand is no. That is it?
I'll take it.
Okay.
Well, their instruction are not required, the wall is not required, but already there's a wall from the army operator.
Okay, then argue on merits.
Yes.
Read the impugn order. What is wrong in it?
Well, judgment is, page 84,
Yes.
Here, there is two notification, there earlier there's 2011.
You read the judgment, please. We'll get everything from the judgment.
This one, page 92 is the
Yes.
relevant portion. Paragraph 21. So for the order of Rajasthan High Court, in case number so relied by the Mr. Medi is concerned, appraisal of the said order goes to show that the same related to 2000 guidelines of 18/5/2011. The divisional bench have taken note of the notification dated 18/5/2011 and passed an order. However, there is no mention of the guidelines issued subsequently on 21/10/2016. It is also not clear that whether notification dated 21/10/2016 containing a fresh guidelines were at all brought to the notice of the bench before the order passed in a said matter. Therefore, I am of the view that the order passed in SR Land Square Private Limited Supra was rendered. In fact, that case and the same would be of no assistance to the respondent number 4 and 5 in fact in the circumstances of the present case. Situated thus, I am not inclined to accept the stand of the respondent counsel that the construction of multi-story building raised by the petitioner company beyond the limit of the 10 meters from the outer wall of the defense installation establishment could not have been raised without the prior NOC from the respondent 4 and 5. As noticed above, this court has already held that the purpose of issuance of NOC for raising construction within the vicinity of the Defense Army installation, the notification of 21/1/2016 will hold the field, and therefore all such issues would have to be considered and resolved in the light of the said notification. I find that from the communication dated 4/4/2020 issued by respondent 3, addressed to the respondent number 5 that the construction undertaken by the petitioner is in between 80 meters to 100 meters away from the boundary wall of the defense installation, represented by respondent number 4 and 5. However, there is no indication that the way the boundary wall constructed by the petitioner company did comply the same in terms of the 21/10/2016. Therefore, a factual verification of the said aspect of the matter would be called for. As such, the setting aside the impugn order at 8/6/2020 in Excerpt 7. This is being disposed of directly responsible to verify the necessity and in light of the observation made herein before and therefore pass a press order. Order pertaining to the building construction permission is issued to the petitioner company, and the said exercise can be carried out in a period of 7 days from the date of receipt of the certificate copy. With all observation written and disposed of, and there would be no order as to cost.
Yes.
Here, the 2011 this notification was not considered. And another thing in 2016 also there's the notification is there,
Yes.
that also in this page 2016 page, it is 60 page 61,
Yes.
and relied upon by learned pen as well as the learned singular as page 61 and page 62, this page 62, I am reading the page 62. It is further provided that where the local municipal law required consultation or approval of NOC from LMA public station commander before a building plan is approved, compliance of such statutory requirements shall continue to be applicable. This is my requirement as per 2016 also. Director your lordship page 122 and 22. This was, my lord, the NOC from the Air Force Authority, my lord, Indian Air Force Authority.
Mm.
I'm reading, my lord, the 2B, my lord.
Yes.
The applicant is, this was applied by the respondent, my lord, before the Air Force Authority, my lord. The applicant is responsible to obtain NOC and all statutory clearance from the concerned authority, including the approval of building plans clearance shall also be obtained separately from any other defense establishment in the vicinity of proposed construction. My lord, this was not, they have never, subsequently applied, my lord. When we objection, my lord, when the construction was going, my lord, then that was rejected by us, my lord. This was another condition, my lord, as per 2016 also, my lord. And the 2016 and 11, there is difference in, my lord, this in the meter, my lord. Earlier it was 100 meter, subsequently it was 10 meter, my lord. So even, my lord, if 2016 is complied, my lord, then, my lord, the approval or permission of concerned military station is required, my lord, this stage, but it was not taken, my lord. Without getting any approval or the permission of the authority, my lord, it was constructed, my lord. This is our case, my lord. And, my lord, there is, my lord, I have shown in before the single bench also, my lord. 2016, my lord, this, my lord, this so far phase 145, my lord. 145, my lord. I've annexed in my FED in opposition before the learned single bench also, my lord. So in this regard, it is the MOD NOC guidelines dated 21/10/2016 are under review in the ministry in consultation with the service and so my lord.
Yes, so.
My lord, it was my lord, this was 20 February 2020.
Yes.
My lord, this was under review, my lord, but now it is reviewed, my lord, because at that time it was under review, and during that it
So
was,
whatever guidelines were prevailing when they sought permission, they will apply.
my lord, even that,
Subsequent guidelines will not apply, gentlemen.
yes, my lord, that is even 2016, my lord, guidelines, my lord, it's
All right. So that is what the single judge has said, that as per the 2016, the NOC has to be considered.
yes, my
That is
lord.
what the direction is.
But yes, but my 2016 speaks, my lord, the concerned local authority, my lord. I will just now I read, my lord.
Yes.
It is, my lord, page, my lord. My lord, my lord, the approval from the concerned military station is required, my lord. In
Yes.
page 1/2022, my lord. The applicant is responsible to obtain NOC, all statutory clearance from the concerned authority, including approval of building plans. My lord, it is required to be taken from the concerned military station, my lord. But
Yes.
this has not taken, and without taking this, my lord, the local municipal permitted to construct, my lord. This is our case, my lord. This is our case, my lord.
Yes.
So, my lord, this was, my lord, not considered by the single gentleman. Accordingly,
Okay. Very well.
direction was the learned single directed, my lord, to verify the area, my lord. But
Read
this,
clause A, 2A on page 61.
my
You
lord,
ignored that. Page 61, clause 2A.
yes, my lord.
Two A applies.
Two, my lord, this is the area, this is the 10 meter, my lord. Earlier it was 100 meter, it was 10 meter.
So for, if they raise a construction in 10 meters, they'll require permission.
My lord, even, my lord, even, my lord, this, my lord, the 2A, B, C. 2A, it is further provide, my lord, to C, 3, my lord. Yeah, even it is 100 beyond the 10 meters, my lord.
Yes.
The three speaks, it is further provided where local
So
municipal.
all right, local, that is for the local municipal body to see that they require permission of the military authority or not. They will see. If they don't, then you challenge that order.
Yes,
That's it.
that is true, my lord.
Then
But after, my lord, is
the view taken by the single judge that as per clause 2A of your guidelines 2016, for a construction beyond 10 meters from your boundary, no permission is required from the military authority. Is absolutely right.
Yes.
It's in. So what is wrong in it?
But it speaks also, my lord, this required from approval from the concerned military system as per clause 3, my lord.
Okay, very well. Thank you.
This is
Anything else?
This is.
Okay, yes, Mr.
Yes, please. Well, if 10 meters still there, my lord, Then it is not required, my lord, virtually. No requirement is there. So the single judge has rightly held, my lord, that since it is 80 to 100 meters, my lord, so no requirement, my lord, taking permission, my lord.
Okay, very well. Arguments heard, judgment reserved. So Mr. Mehdi has on instructions stated that the authorities, appellant authorities are not agreeable to the observations made by this court on 19/7/2023 as to the issue of permitting the respondent hospital to raise a boundary wall on its land. The said direction was given by this court, keeping in view the fact that allowing the facility to function without a boundary wall may pose a risk to the defense installation. Our Mr. Mehdi submits that the defense installation is already encumbered by a boundary and thus, no risk would be faced by it, even if the boundary wall is not constructed by the respondent. Okay. Arguments, final arguments have been heard. Judgment is reserved.
Item 13.
Sorry, my lord, it was called. I could not be present, my lord. I think the other side is required in this case. Sorry, that's
What is
online here. He's asked for timing already. Your lordship has given one.
timing
Passover has been.
once it has already been done? What is the matter, Mr.
These two,
Das?
I have a difficult situation here. Because earliest judge has said, single judge says, he has no legal right. I have no legal right. Because
Two step pumps
Two
coming up
pumps.
close by.
two pumps,
Let it come up after vacation then.
only
List
difficult, any orders,
Eight.
they start, they may start. That will be subject to further orders of this court. That's only I have just.
Counsel for the respondent, please for time. We make it clear that any construction raised on the retail outlet subject matter of consideration in this appeal will be subject to the outcome of these proceedings.
Deeply obliged.
Shall remain subject to the outcome.
That will help. It
List,
will come after my date,
after
whichever
puja,
it's.
list on 16th, 17th November.
Deeply obliged. Both is 14.
14 also?
Same.
Same.
Deeply obliged.
Item 15.
One, I'm sorry. Well, one request is in made. In Kohima bench, I go to Kohima bench. The format here in Guwahati and format there in Kohima is lot of differences there.
Format,
Filing. So
Which-
sometimes what is done, my lord, I thought that I will just tell
yes,
your lordship.
that's welcome.
My lord, because normally it has been prepared. There are clerks, a few clerks. I think there is no clerk at all.
There.
Clerks in Kohima. So normally it is prepared from here. So we go there and it is.
Then
filed
you have to
before-
change the format.
That's the whole problem.
We'll check right today itself. We'll check.
Yes, that's only a humble
Mr.
request.
Agit, tell the Joint Registrar Judicial to check this discrepancy in formats at the Kohima bench today itself, and it should revert to us.
So only.
And perhaps you can, we'll get it from Kohima.
Yes.
What they are
What's the
demanding.
format, like, and
We'll get the format.
we go, we just prepare it. We thought of just filing this.
Naturally.
I'm sorry.
There has to be a proper parity.
Yeah, so that it becomes easier for
Yes,
everyone.
no doubt.
I'm deeply obliged.
In Itanagar, the format is same we
I
find.
think Itanagar is same.
Kohima, I have not been there, so I don't know actually.
That's right. And suppose a particular person is outside India, then that's your lordship knows that there is a consulate they have to. There's no question of again being notarized. They notarize. There is a notarized, I think that's also has to be looked into it.
We'll look into both issues.
Right. Deeply obliged. Ma'am.
What is this about?
Lord, it is regarding one, the applicant who once took admission in an MBBS course in the year 2000.
Oh, that is the matter.
Yes, my lord.
Okay. Yes, madam.
And we have filed our affidavit also.
The NMC has also filed the, what is the stand of the NMC? Hmm?
Instruction from NMC is required on earlier date.
NMC has filed the affidavit.
Yes, my lord.
You're not aware?
No, Lordship, on earlier occasion,
The
you
NMC
please
was
the-
required.
kindly
Okay,
please the.
there was some order.
Yes,
Let's read
Lordship.
the order. What is the order? This, the situation has changed now. That seat is no longer available in view of yesterday's order.
Earlier, definitely, yes.
That seat is not available now. So what will be your remedy? Next year. The remedy will be in the next year now. He has already allowed 12 years to pass by. Let there be one more year. There's no way out. So what do you want now? I'll take down on the previous date of hearing, this court had posed a question as to whether the appellant can be allowed to continue his MBBS course, which had been discontinued on account of health exigencies, which he was compelled to discontinue on account of serious health issues by occupying the seat reserved for ST within bracket P. However, this court is conscious of the fact that the said seat of STP has already been directed to be accorded to candidates of tea plantations, tea plantation workers category by an order passed yesterday. In this background, counsel for the appellant is required to take further instructions. Let's stop for puja break.
Top of the list matter, item 1.
Yes.
Please, your lordship.
Uh.
My lord, against the impending order of the London single judge, my lord, page 88 onward by the order. It was against the order of the revenue board, my lord. In the revenue board, London board, my lord, remanded back the matter to the deputy commissioner, my lord, considering the facts and some, my lord, question of, my lord, the unregistered deed, my lord. But London single judge, my lord.
Is there someone representing the private respondent?
Yes.
There? Okay. Yes.
So,
Hmm.
my lord, London single judge, my lord, in my considered view, my lord, is not correct. Because, my lord, from the beginning, my lord,
Yes.
land in question of, my lord, 1/2 Lusa is the petitioner, this appellant, and their father was the owner, my lord.
Mm.
And thereafter, my lord, as per their case, my lord, they have given as a rental basis, my lord. But the my lord, the respondent here in my lord, the father of the respondent,
You have to tell us purely on questions of law.
yes, lordship,
This is a special appeal, writ appeal
lordship.
against an order of the single judge in a matter pertaining to revenue proceedings.
Yes,
So
my lord.
the findings cannot be assailed on facts. Come out with the illegality in the order if you can find.
Illegality of my lord, basically, section 17 of the registration act, my lord.
Yes, what is that?
Section registration of section 17, read it
Hmm.
49
Hmm.
of the registration act said that, my lord, my lord, any my lord, agreement or deed, my lord, which value
Which is not registered. Value is
Yes.
more than 100 rupees.
100 rupees,
Yes.
then it is, my lord, not my lord, valid document, my lord.
Hmm.
And I have some judgment of Honorable Supreme Court in this regard, my lord.
There are
So-
recent judgments of 2023
Yes, my
on
lord.
this very issue. Let us see. What is that judgment?
My lord, I have one copy only, my lord. This is MS Paul Rubber Industries Private Limited versus
Hmm.
Amit Chandra Mitra, my lord.
What is the
This,
citation? Can you tell us the citation, please?
my lord, I could not able to get it, my lord, from internet, my lord. And other judgment on the similar line, my lord.
Hmm.
These are of, my lord, year 2000. Lordship, one judgment, 2018-7, SCC 639.
Hmm.
And another judgment, Lordship, 2010-5, SCC 401. Yes, Kaladevi, my lord.
Hmm.
And another judgment, my lord, this is also important, my lord, 2008 Supreme Court 564. KV Shaha and Sons Private. This judgment also, my lord, reflected in the recent judgment, my lord.
Hmm.
Considering, my lord, all this judgment, my lord, one thing is clear that, my
Hmm.
lord, so, my lord, this is, my lord, compulsory registration as per section 17, my lord. But this, we are also, my lord, pointed that this, my lord, sale which was done, my lord, this is, my lord, fake one. And earlier they stated that there is a lease deed also, my lord, which was also not registered, my lord.
Hmm.
So both the, my lord, deed by which they, my lord, try to, my lord, establish their right, my lord.
Hmm.
This is, my lord, fraud as well as, my lord, against the principle of, my lord, section 17, my lord,
Hmm.
of registration act. Read with, my lord, transfer of property act also, my lord, which is not allowed, my lord. But the learned single judge, my lord, so citing some judgment, my lord,
Hmm.
but it can be used, my lord, as a, my lord, collateral purpose, my lord.
Hmm.
But this,
Unregistered sale it can be used for collateral purposes.
yes, my lord.
Yes.
But the initial sale, we are, my lord, disputing that, my lord. And the learned board also, my lord, took note of that, my lord.
Hmm.
And accordingly, my lord, send it back to the deputy commissioner, my
Hmm.
lord. Because some disputed facts are also there, my lord.
Hmm.
So my humble, my lord, prayer is that, my lord, this order of the learned single judge is not in conformity with, my lord, section 17.
Hmm.
Read it.
Come to para 31 of the order,
Lordship.
judgment, single bench judgment.
Yes, my lord. Adverting the facts of the present case, a report of the Lat Mandal, which was relied upon by the concerned circle official, clearly revealed that possession of the land in question was being enjoyed by the petitioner for a long time. She had constructed boundary wall and house thereon and was paying land revenue, municipality taxes, electricity bill, etc. One of the son of the original annual patta holder, Pancham Pandit, admitted that neither he nor any of his brother had any possession over the land in question for the last 15 years, 15 years from the 2003. This factum would clearly indicate that possession of the land in question was with the predecessor in interest of the petitioner and not with the original pattadar of the annual patta. On the other hand, learned counsel for the respondent number 4 to 6 submitted that at the time of the hearing that the petitioner and her father were tenants. Even if this contention is accepted, status of the petitioner or that of her father would be that of tenant having permissive occupation.
If this is the question, then effect of rule 1(2)(c) of the settlement rules will come into play. Since original annual pattadar had transferred the possession of the land to the predecessor interest of the petitioner, it will entail non-renewal of the annual patta to him or to his legal heirs. Therefore, no fault can be founded with the order passed by the land circle officer suggesting that the land be made permanent land, as the possession of the annual patta land had been transferred in violation of the rule 1(2)(c) of the settlement rules. This aspect of the matter were not considered by the board while setting aside the affirmation order of the additional deputy commissioner.
So basically, your predecessor being annual pattadar, the learned single judge holds that he had no right to transfer. And there is no dispute about that proposition.
Lordship. Yes.
Ultimately, the direction has been given that the land should be made over to the government. That is the consequence
Yes.
of an illegal transfer of an annual patta land. What is wrong in the order then?
My lord, we have not transferred, but we admitted that they are tenant.
You had executed a sale deed, which though not registered,
No, my
but
lord, we
still
have-
you put the respondent into possession by virtue of that deed.
my lord, our case is we have not executed any.
So you have not filed an FIR, we presume.
But it was pending before the my lord, deputy commissioner initially thereafter.
Have you filed any suit for cancellation of the deed?
Well,
No.
Since matter is adjudicating before the
The validity of the registered sale deed could not have been examined, unregistered sale deed could not have been examined by the deputy commissioner. The document could have been tested either by filing a FIR or by filing a suit, which you did not resort to. Then what is your right now?
my lord, since landed board, revenue board has my lord rightly pointed out. So thereafter we
There
can.
is
my lord,
nothing wrong in the orders
Right.
for which the revenue court directed a remand. Nothing wrong.
But we have disputed this manner sell it because my father has. not
Disputed in the
used
manner, what manner?
Lordship.
It's mere, by mere ipse dixit, the sale deed can't be questioned. There has to be some proceeding.
Right.
Where is that proceeding?
But my lord, before that, they have stated there one lease deed also, my lord. That lease deed also not registered, my lord. It is a unregistered
original
lease
record
deed,
here?
my lord. And
Original record of the board of revenue. No. We'll call for the record. We'll see the pleadings of the parties.
lordship.
Let the original record be summoned from the board of revenue. Assam Board of Revenue. Original record of case number 183 RA within bracket K 2005 be summoned from the Assam Board of Revenue.
Yeah.
List thereof. List of record is received.
Obliged.
Item number 2 and 3.
Yes.
May I please, your lordship? My lord, this is the matter, my lord. The appellants before my lordships are, my lord, the madrasa TET qualified candidates, my lord. My lord, what has happened, my lord, when, my lord, there was a recruitment process had been initiated, my lord, in the year 2012, when this madrasa institution in the state of Assam was existing. My lordship is well aware, my lord, that these madrasas are now being converted into, my lord, general schools. And my lord, all those staffs who were working in those madrasas has also been absorbed, my lord, and they are being allowed to continue their services. Now, my lord, a recruitment process in the year on 12/9/2012 had been initiated for the purpose of filling up of the vacant post in the madrasa institutions, my lord, as assistant teachers without following the mandatory requirement of the NCT prescribed qualification, my lord. Then, my lord, a PIL had been filed before this honorable court that as these institutions are equivalent with the secondary level schools, so therefore there cannot be any relaxation of the NCT qualification. Accordingly, my lord, when this honorable court was adjudicating the PIL, then, my lord, state of Assam has come up that yes, we have committed a mistake. So we have abandoned the selection process and we are going to conduct the TET. Accordingly, my lord, this madrasa TET examination by way of a notification, my lord, had been conducted in the year 2014, my lord. And altogether, my lord, in various categories of, my lord, posts, this madrasa TET examination had been conducted. Just for a moment, my lord, if my lordship allows me to draw my lordship's precious attention to an important annexure, my lord, is at page, my lord, the madrasa TET examination, my lord, which has been conducted. My lord may be pleased to find that notification, my lord.
That is not in dispute, we presume.
Yes, my lord, that is not in dispute, and accordingly, my lord, the TET examination was conducted and 20,000 candidates altogether had been passed out. Now, my lord, what has happened? The government initiated a recruitment process for manning the vacant post in those madrasa institutions in the year 2015. A de novo process had been carried out. But, my lord, for the various reasons and litigations, my lord, those appointment process could not be culminated. And as a result, my lord, what has happened in the meantime? In the year 2020, the state of Assam has came out with a, my lord, legislation, the Assam Repealing Act 2020, by which, my lord, these madrasa institutions and the Provincialization Act, by which these madrasas were provincialized, had been revoked. And, my lord, had been converted into general schools. Now, my lord, as these petitioners, my lord, had been born, or the purpose or the product, my lord, the government has made for the purpose of manning in the madrasa institution, they could not be appointed or they cannot be used their degrees because these madrasas are no more. Therefore, my lord, what has happened in the state of Assam, there was a dearth of TET qualified candidate, general TET qualified candidate. And accordingly, my lord, the government has decided from this madrasa TET qualified candidate, we are going to give some of the persons the benefit of appointment in the general schools. So, my lord, those persons has also been appointed, some of the persons.
Some of the madrasa TET teachers have
Madrasa
been
TET qualified had been manned in the general schools. Now, suddenly, my lord, in the year 2019, by way of a notification dated 5/1/2019, my lord, the government has come up with a policy that as the structure and content of this madrasa TET qualified madrasa TET examination syllabus is quite different with the general TET. So therefore, my lord, these they cannot be equated. Madrasa TET and the general TET had been distinguished, and they are the government has taken a conscious decision from henceforth that we are not going to, my
allow
lord,
them for general schools.
exactly, my lord, exactly, my lord. And accordingly, my lord, those notifications and the subsequent notifications which has barred this madrasa TET qualified candidate has been put into challenge before this honorable court in a series of writ petitions, my lord. And the learned single judge, my lord, for the reason cited in the judgment, has upheld the decision of the government. Now that learned single judge order, we have SL before my lordships.
This is the only appeal or there are more appeals?
My lord, another appeal is there, but that is slightly different, my lord. That is item number 3, my lord. But there is no other appeal is
No
pending
other
as per
appeal,
my
because
knowledge, my lord.
the writ petitions were large in number.
Large in number.
Yes.
My lord, altogether 20,000 person has been affected, my lord.
Now we understand.
My lord, my
Yes.
lord.
Okay.
So, my lord, the issue is required to be heard on length, my lord. So, my lord, if my lord, my learned friend is also seeking some time.
When do you want?
Last,
He never indicated.
not today, my
He is
lord,
always prepared.
not today, my lord.
We find Mr. Mazumdar to be prepared
No, he is
any
always-
given day
He is always
for
prepared, my
any
lord.
matter.
My lord,
So, if you want time, we don't mind.
my lord, my
You
lord.
come back prepared because this is a very big issue.
Yes, yes,
Which will have a far-reaching impact
yes, yes.
on large number of persons.
Yes, yes, my
When do you want?
My
Tell
lord,
us.
another thing, my lord, I want to apprise my lordship, my lord. My lord, that issue of the repealing act, my lord, had been put into challenge before this honorable court also, my lord.
Okay.
And my lordship was pleased to uphold this repealing act 2020, that the closure of the madrasas, my lord, and now that issue is also pending before the honorable apex court, my
So
lord.
let that issue be decided
Yeah, my
first.
lord. Yes, my
That
lord.
will also have a consequence.
Yes, yes, that will have also have a consequences, my lord.
So
My lord.
as stated by Mr. Boyan, the issue, the notification whereby the madrasa institutions were abolished,
My
was concluded by division bench of this court. However, now the controversy is pending before Honorable Supreme Court. As per Mr. Boyan, the outcome of the said litigation could also have a material bearing on the fate of the appellants here.
My lord.
He thus prays that for the present, consideration of this writ appeal may be deferred by 8 weeks,
My lord.
ordered accordingly. Both,
My lord, both can be, my lord, but in the next one, my lord, there is an interim direction, my lord, that the Arabic category of, my lord, persons, my lord, had been allowed to participate in the recruitment process for the Arabic post because they are expert in Arabic, my lord.
okay,
Now pursuant to an advertisement in the secondary level schools, my lord, these two applicants has offered their candidature and my lordship was pleased to pass an interim order that they should be allowed to participate and their selection credentials should be kept on seal cover, my lord.
okay.
Now it is still pending in the seal cover, but my lord, they are not appointing. If my lordship allows me to appoint us, which is subject to outcome of the my lord, writ appeal, my lord.
The decision in the writ appeal will govern whether they would be.
Can you do it provisionally without
Provisionally,
creating any
and,
equity?
my lord,
If they have succeeded,
yes,
do it provisionally, they will teach. They will take an undertaking from them that their appointment will remain subject to the outcome of the appeal.
The original writ petition was dismissed on the basis of this writ petition, my lord.
Now we understand. But you see, this is specialized language teachers. And you need those teachers. There's no dispute. Do you have enough number of teachers? Tell us.
that,
Can we?
And I'll have a talk with the department if there are posts and if they
no,
can.
they are post.
I'll have a discussion.
So when do you propose to?
Or should we have it immediately after the visit?
17th?
No, my lord, before the vacation.
Let it be
Before the vacation, my lord.
Let it
After
be
vacation?
No, my lord, before the vacation, because.
Before 18th, all right. Writ appeal number 104/23
My lord.
shall be detached and listed on 18th for enabling Mr. Mazumdar to take instructions.
Obliged.
Obliged, my lord. I love it.
Item number 6 to 8.
Rubber board.
Mal.
Hmm.
But on last occasion, Lordship has directed us to get the records. Lordship, the records, the certified copy of the records, I have.
You retained?
I have written.
Yes.
But the issue here as raised by the petitioner in the appeal, Lord, is as regard the procedure followed by the rubber board while conducting the promotion exercise in 2009 and in 2009 and
Okay.
2000 and 2014.
Hmm.
But I have gone through the records, Lord.
Hmm.
As regard the procedure followed while promoting the person, Lord,
Hmm.
I have seen, Lord, the in 2009, Lord, the vacancies which were for the SC/ST people could not be filled up in 2003, 4, 5, 6, Lord. Those were filled up in 2009. In 2003, those posts were for SC/ST and the candidates were not there. Those were filled up by general candidates. And ultimately in 2009, the available SC/ST candidates were promoted in those roster points. And considering that roster position of 2009, Malad, the 2014 promotions were done to the next cadet.
Okay.
That is the procedure they have followed.
So what is the issue in these appeals? We don't recollect precisely. What is the issue involved?
But a submission, a synopsis has been given by the appellant. They have challenged the order. The learned single judge, while passing the order, impugned, has said
Yes.
that because of the delay, the petitions were basically not entirely.
Okay. Only on delay. Only on the ground of delay.
On many people not decided. If Lordship is holding the writ appeal number 250 of 2020, the judgment of the learned single judge, it starts at page 190.
Yeah, we have the judgment, yes.
Lordship.
What paragraph?
Paragraph 9 was the contention of the respondents, Lord. And the final decisions, Lordship will from page 12 onwards. Page 12 onwards, Lord. Lordship. There is no dispute at the bar that the DPC is the authority competent to take into consideration the applicable rules in force governing the entitlement of to promotion from amongst the list of persons who are considered eligible to be considered for promotion to the next higher promotional post. The learned counsel for the petitioner has made his meticulous submission on the manner in which the DPC is required to consider the cases of reserve category candidates for promotion of quota.
Reading from para?
I'm reading from page 195, para 12.
Yes.
Lordship. I'm reading again, my lord. There is no dispute at the
Are the
bar.
judgments separate in all the cases?
No,
It's a common judgment.
it's a common judgment.
So the para 12 is I have considered the submissions. That is what the para 12 is. I have considered the submissions made by the learned counsel. Where are you reading from? There is no dispute about the fact.
Lordship, that, yes. There is no dispute.
Yes.
Yes, my lord. There is no dispute. There is no dispute at the bar that the DPC is the absolute authority competent to take into consideration the applicable rules in force governing the entitlement of promotion from amongst the list.
It's not, no.
Lordship.
We are reading from this D. Suresh.
No. Kindly take
Why
up.
are the judgments
kindly take-
separate?
Yes,
Are there
yes,
different
yes, yes.
judgments?
No, judgment is separate. D. Suresh is a separate case, my lord. It was decided recently.
D. Suresh is a different
Is
controversy.
a different. Kindly take up readable 250 of 2021.
Oh, then away.
Item number 7 and 8.
Yes.
Those are the 2021 appeals, my lord. Kindly come to page 195.
Refer to the para of the order.
It starts at page 190, my lord. And kindly come to 195 para 12. There is no dispute at the bar. Has lordship got, my lord? There is no dispute at the bar that the DPC is the authority competent to take into consideration the applicable rules in force governing the entitlement to promotion from amongst the list of persons who are considered eligible to be considered for promotion to the next higher promotional post. The learned counsel for the petitioner has made his meticulous submissions on the manner in which the DPC is required to consider the cases of reserve category candidates for promotion of quota earmarked for reserve category. He had taken pains to explain the distinction between shortfall of reservation and number of backlog reserve vacancies in the cadre. This was done to stress on the point that as the vacancy position for 3 years was considered by the DPC together, without taking into account the year-wise vacancy, however, by taking into consideration that the cadre strength of the post of ADO was 107, nonetheless, in all the four.
So their grievance is the DPC should be considering year-wise vacancies.
Year-wise vacancy. That is one of the grievances.
So what is wrong in that proposition? That is what the precise manner in which promotions are to be done.
But I am pressing with your lordship, what has followed by the board, that is what I am pressing. In fact, the board has considered all the vacancies together.
Was it permissible?
Together.
Is it permissible in law?
Well, in 2003, 2004, 5 and 6, the persons for the reserve category SC/ST persons were not.
So you carried forward.
Well,
When you made merge them in general.
In fact,
On the basis of yes,
those posts were filled up by general
filled up by general category.
unreserved
Yes.
category.
Okay.
Although I have not seen in the record any decision as regard de-reservation, but they have filled up. So ultimately, that shortfall they have counted, and in 2009, the post which ought to have gone to the SC/ST that has been filled up.
They were given to general category candidates.
Earlier, it was given to general category. Now it is given to in 2009, those 13 posts were filled up.
13 posts were given to SC/ST category.
SC/ST category.
Okay, and these appellants lay claim to those posts.
This appellant says that that was a wrong procedure you have followed. Ultimately, on the basis of the 2009 promotions, the following the roster position in the 2009, the subsequent promotion in 2014 for the post of DO has been done. The Prasanto Buro, one of the appellant, he was promoted in 2006. He said that his seniority should have been maintained, but finally, because as per the 2009 we have done, he was not promoted. That is why he has raised grievance. Against in 2014, he filed the writ petition challenging the 2009 one. That you cannot do. That has been challenged lately. Read further. Therefore, the challenge to the consequential office memorandum.
Will we be able to conclude today Because this bench is only till 1 today. You're having a different bench tomorrow after lunch.
So for the procedure is concerned, if lordship is deciding, two parts are there. Matlab, so for the procedure adopted by the board is concerned, and then to that effect, the challenge is there. This is apparent from the record. If lordship is taking
Would
up,
you like to show the record to the advocates for the appellants?
I have that. Yeah.
Would you like to see the record, please?
Yes.
Hmm?
Yes, well, in last occasion, your lordship make a query that whether the roster point seniority is given to them. Because
Have a
now,
look at the record. Make your notings. Then you point out whatever you can highlight from the record.
Yeah.
There are any flaws, you point it out. Record, copy of the record is with us. We'll take note of it and then decide the issue. Okay.
after some time,
Shall submits that he has written certified copies of the original record of the board. He shall permit the counsel for the appellant to inspect the record and make notes so that the issues raised in these appeals can be canvassed in reference to the position of record, position reflected from the record.
And we'll come back tomorrow.
Not tomorrow.
After the,
Now it goes after puja vacation.
I'm appearing for the private respondents hearing, may also have the.
You can also
Yes,
counsel for the parties कर दीजिए. Re-notify on 30th November. Yes.
13th of November.
maybe little bit earlier, that's requirement.
We already given all dates in the month of November. On hearing days, we already fixed matters.
But I'll give them record, they will inspect and return me.
Of course, of course.
Not.
You invite them to your chamber over a cup of coffee.
Well, I'll give them here also, here only, they will inspect and give. I'm obliged.
Item number 9 and 10.
May it be the lordship. This is this is regarding my lord appointment of distributors for LPG. The impugn order was set aside by learned single judge, but my lord, because my lord, I have not given, so lordship kindly go through the
There was
judgment,
some
my lord.
affidavit filed by Mr. Bhuyan.
My lord, I'm appearing on behalf of my senior, Mr. K. Bhuya. My lord, I'm appellant in item number 10 and I'm the respondent in item number 9. My lord, an additional affidavit has been filed in writ appeal number 262 2023 for furnishing the order dated 29/9/2023, passed in writ petition number 5718.
Is it there?
Which is pending, my lord.
It's not been brought on record.
No, my lord.
What is pending?
It is pending.
He was to.
You have been given a copy,
No,
madam?
my lord.
No.
Yes, my lord. What happened, my lord? In spite of the order of the honorable court, the authority has cancelled her dealership. Therefore, that order has also been challenged in another writ petition. So, my lord, it is actually notice is issued, but that is, my lord, not the subject matter of this case. Because in pursuance of the, my lord, in compliance of the order of this honorable court, her dealership is cancelled. How she can again approach this court challenging that order?
That
So,
you,
my lord,
My lord,
so, my lord,
that
is
you can
not
always
even there.
argue.
my lord.
Because that is
actually,
not
the
maintainable. my lord.
cancellation order
Petition.
has not been challenged by the respondent number 4. Dayal Chandra Paul has not.
Call your senior, call your senior. Okay, I'm arguing, I'm placing the matter because for last 5 years, the issue is pending. That's why, my lord.
All right.
Yeah.
Proceed.
If your lordship kindly see, my lord, paragraph, the page, my lord. Page 294, my lord.
What are you referring to? You are referring to what?
My lord, that page 295, that. the
Impugn order.
selection. Because, my lord, impugn order is cancelled because she is
What?
legally not.
All right, you are
entitled.
reading from the judgment of the single judge.
Judgment of the single judge,
Read
my lord.
paragraph.
Yes, my lord.
Paragraph.
Paragraph, last part of 26, my lord, page 294. Yes. The learned page 26, the para 26 I'm reading, my lord. It is page 94, 294. The learned counsel for the petitioner strenuously argued that in view of the setting aside of the letter of intent so and so, letter of appointment amendment, this court should direct the respondent ISL authorities to issue the letter of intent in favor of the petitioner. This court is of the opinion that this said submission is totally misconceived in as much as clause so and so of the guidelines stipulates that in case there are more than one eligible applicant, selection of the LPG distributorship will be done through computerized draw of lot from the eligible applicants for that location. It appears from the records that apart from the petitioner and the respondent number 4, there are 12 other eligible applicants. That is wrong, my lord. No eligible candidates were there, not a single one. Under such references, the question of issuing a direction to the respondent ISL authorities to issue a letter of intent and letter of appointment to the petitioner do not arise. Further to that, it is also relevant to take note that the other applicants are not parties to the instant writ petition, and as such direction would be contrary to the constitutional norms. What happened, my lord? I have stood first in the first draw of lot. Therefore, without giving any notice, they have cancelled and gone for the second draw. And my lord, when in the affidavit reason is shown that, my lord, it is in the judgment itself, my lord, that if one intending applicant filed 2 applications, they have cancelled on that, my lord, plea that I have filed 2 applications.
2 applications.
Yes, my lord.
Okay.
If your lordship kindly come to page 247 of the judgment,
Yes.
clause 5, para 5, my lord, clause 10.4.2 is very relevant for the purpose of the instant dispute, and the same is quoted here and there. And so, 1 application per applicant for a location. Applicants should submit only 1 application for such location. In case more than 1 application is received from an individual, all the applicants would be clubbed together and treated as 1 application. In such cases, application fees received against all other applications would be forfeited. Only the fees will be forfeited, but my application cannot be treated as cancelled. Secondly, when if your lordship come to the who have minor complaint to the affidavit in opposition filed by the my lord Indian also.
Where is the order whereby your dealership was cancelled? Where is the order? Can you show us the order, please?
Yes, my lord.
Arey, not you, gentlemen. Where is the order whereby your dealer or application was cancelled?
My application was not cancelled, my lord. They gone for without notice, without anything.
Second-
for second draw.
Second draw.
Yes.
Okay.
So, my lord, I'm placing the affidavit. filed by
Affidavit.
the-
Let us see the affidavit.
Yes, I see, my lord. Authority. Page 127,
Yes.
paragraph 4. Paragraph 4. Paragraph
Let her point out. Don't interrupt. Yes.
127, page 127.
Yes.
4. With regard to the statement made in paragraph of the writ petition, deponent that they had submitted 2 online applications, filed so and so, as per unified guideline for selection of LPG distributorship, October 2017, plus so and so, only 1 application per applicant is allowed for a single location. It is very intelligent. Durgam, Khatra, Bitra, there, because in case more than 1 application is received from an applicant, all the applications could be clubbed together and treated as 1 application. Also, in such cases, the application fees received against all the applications would stand forfeited. As the scrutiny of application was done online, the online system could not detect the submission of 2 numbers of applications by the same applicant, so and had mentioned his father's name as differently in both the applications. The father's name had been stated to be Santosh Paul, and in so he had mentioned as Santosh Paul. Spelling mistake, my lord. Because it's a very interior press. The computer, he cannot run computer, so some other authorities called. Thereafter, my lord, next paragraph, my lord. Draw lots of so. 1 which Joelson was declared as the selected candidate for the selection Jamla, and after his selection, certain verbal complaints were raised by other applicants who were present on the date of draw, stating that the petitioner has applied twice, and as such his candidature should be cancelled. Later on, a formal complaint was also received on so-and-so from one Srimati Nandita Das. She is a resident of Bharolumukh, my lord only, against the selection of the petitioner, stating that he had applied twice. The matter was thus examined by the authorities, and it was found that the allegation raised in the complaint that so-and-so was true. Accordingly, the petitioner's selection for the Jamrai location was cancelled against the application number so-and-so, and he was informed about the cancellation of his application so-and-so, filed letter number so-and-so.
Yes,
I never
Mr. Council, what do you say to this clause which provides that if there are more than one applications, you are required to club them?
The basic thing is this is a lottery.
Yes.
This is the draw of lot. Now giving if one particular applicant submits two sheets to the lottery method.
So the options become wider.
Exactly.
The chances become more.
Clause was there.
Hmm.
Now while clubbing, when we found that there are two particular applications for the same applicant, we might have rejected her outright right there. But we have not done so. We said that this draw was wrong since it was pointed out. So now we are.
So fresh draw based on repeating one application only.
Received that, we served her a copy that was received by him.
Yes.
Then we have considered the second draw. The second
Yes.
draw is considered.
Whereas you have considered her application also.
Yes.
Yes.
Then the private respondent.
Okay. Thereafter, you have cancelled the application of the private respondent also. Yes, that is what.
What has happened is, madam has challenged the candidature of the private respondent, saying that she is not a resident of that locality. Now the single judge has observed that yes, you are not a resident. That's why your candidature should be cancelled, and the draw among the remaining candidates
Should be reheld. That you have complied.
now agreed by this particular new draw.
New draw.
Procedure, because we consider her application of
Yes.
in compliance with the single judge draw.
The application of this writ appellant here also. Yes. Yes. So in an event, respondent number 4, to whom you granted in the second draw, is not compliant because
As per
the residence
Yes, she is not a.
not as residents of the same area.
Cancelled, compliance of the single judge order, we have cancelled, and that has been challenged.
What as per your guide, that's what we are asking. That challenge is in a writ petition before the single judge or this court.
Yes, in the for the single judge, and that has what has been, he has been trying to bring on record that.
But that writ petition is not with us, no?
The order is there, my the order passed them, my lord.
Which order?
My lord, the ISL authority after the judgment passed an order that has also been challenged.
My lord, this,
They have a right to challenge. We are not bothered about it.
Yes,
this was filed
Yes.
on 6 October 2023, my lord. And my lord, it is pending as of now. And my lord, an additional affidavit has been filed on 6/10/2023.
What is the second appeal about? What is the second appeal about?
Second appeal is by the private respondent challenging.
Challenging the.
Rejecting her.
Okay, so
And may I submit-
let's see that appeal first then. All right, argue.
May I submit, my lord? That my lord, other applicants at page annexure 10, my lord, other applicants except me, my lord, nobody fulfills the criteria of residence. Because I
Okay.
am, yes. So
So
there is no.
there
question.
were in draw of lots, how many applications were considered? If what she says is correct,
14.
so then how can you say that they did not fulfill the criterion?
Criteria, they are not residents. Somebody is from Bharolumukh.
Maybe, but you can't oust them at your choice.
No, my lord.
If they-
It's not choice, my lord. They have to fulfill the criteria.
Madam,
Yes.
you have not questioned their candidature on the ground that they are
No,
not
no,
residents of
I-
the same.
Because.
But why
they are-
didn't you implement them as a
no,
party?
no. They are, my lord, others also, they are not.
Mr.
my lord.
Council, in any event, you will hold the fresh draw of lots again by including those people. How they are prejudiced by this order? By the fresh draw of lots, how they are prejudiced?
The fresh draw will be considering madam's candidature also.
Also, obviously.
I may get, I may not get also.
Move for the field.
Yeah, you may not got, you may not got. Yes.
Because the cancellation was wrong.
No, it is not wrong because you took a double chance by 2 separate applications. Your chances increased 50%.
No, my lord.
Yes.
Club together means one application considered,
No, 2 applications were put in draw of lots, not one.
2 application I have filed.
Yes,
The club
both,
together means
they were
one
not
means
clubbed.
One application.
They could not be clubbed because the description or your father's name was
Only
wrongly
father's
spelled.
name was spelling
Yes,
mistake,
so
spelling
they
mistake, all.
treated your applications to be by separate persons. That is the reason. So that is absolutely right.
No, my lord, your lordship will
Okay,
kindly try to
very well.
understand, my lord, that my lord, the father's name was P.A.U.L. Paul. But my lord.
It's a
regarding
specific
typing-
case by the corporation that they treated your applications as separate applications in the raw law. So you got a double chance.
Clap to
They
get-
could have outright rejected your candidature. Rather, they should have done that. But they have given you a chance. You should feel happy by that. You take our observation, we'll say that it's a fraud, you should be outright rejected. Take the order.
No, my lord, sometimes it is a very interior.
No, it's a very, very
It's
designed,
very interior place. The
immaterial,
computer person, he has, my lord, committed wrong. but not
immaterial,
very
madam.
well. But my lord, father's name, other details, everything same.
So
Name
it is
not
a
different.
computer which is identifying the applications, inspecting the applications. The computer will consider
Everything
the
is
applications to be
in two
separate.
application- No, my lord, two application, everything is same, my lord. Why your lordship? Everything.
Try
is
telling
same.
that to the
One-
madam,
one-
try
that-
telling that to the computer. The computer doesn't act as a human being. It will treat even if there's a single
You is
difference,
missing. Only you is missing. Other
Even-
description, everything is
even
same.
if there's a comma full stop difference, it may read it differently.
No, my lord,
So,
it-
no.
Other his date of birth,
We'll-
other official
Okay,
residence, address, everything
It
same.
is a fact, madam, that your applications were treated as separate applications in the draw of lots.
No,
That
my
is a
lord,
fact you can't
complaint. They are telling about my lord, complaint, that somebody complained. But the complaint was also to be looked after. I'm a resident of that particular area.
Oh,
They are not
you get all right. We will make an observation.
notice.
We'll look from the record. And if your two applications have been treated separately in the draw of lots, then we will make an observation that's an attempt to fraud, attempted fraud by you. So you are ousted. You want that order, we can give that.
What can I do, my lord?
No,
There
all
are
right,
some
then
typing mistakes.
okay.
While filing
Learned counsel
applications-
for the
No, my lord,
corporation
your lordship will
shall,
kindly bear with me.
we'll do that.
Filing, my lord, application, here also, for judgment also, some typing mistakes are error. That does not mean.
It's a
all
draw of
details are
lot,
same.
madam. It's a draw of lot where you get two chances instead of one.
Club together, my lord.
They were
Law
not
says
club.
that they club together.
They could not have been. That is the reply. To get the record, we'll take that exercise now. We'll do that exercise here. We'll
Yes,
examine
my lord.
how many.
Record my place, my lord. Only for one letter, my lord, I should be deprived.
Yes,
Otherwise, my
yes,
lord,
that's a fraud played with the
everywhere
corporation.
typing mistake is there.
Okay,
In
we'll deal with that.
Our
We'll,
petitions also typing mistake is there.
we
From
will,
the judgment also typing
Madam
mistake is there.
Saikia, we will deal with that argument and we'll make that observation.
But
We are
my
making it loud and clear.
But my lord, that the legally I am entitled, my lord.
We'll see whether you are entitled or not.
Because
If
my lord,
your two applications have been treated separately in the draw of lots, then you are not entitled. That is for sure. All right. Counsel for the corporation shall keep the record pertaining to the first draw of lots available for the court's perusal. We are proposing to examine the record to find out whether the two applications were filed by the appellant were treated as distinct applications, which would have increased the chance of success in favor of the appellant unfairly. Thus,
everything. else-
let the record be
Name,
produced
address, home address,
on the next
everything.
date,
Next
list
date,
on 8th November. Let the record come, we'll see.
Much obliged, my lord.
Well, other address, everything, application is also there, everything same. Because my lord, they are not sure whether the application has gone or not. Because they are
That-
village people.
That will verify
Village
from the,
people, that's why, my lord.
we will
That's why-
verify from the original
Yes, my
record.
lord.
Village people are
Surely.
very smart.
Both the applications should be put together, then your lordship will compare. If other statements are different.
Next.
First meter 20.
8 November.
Yes. Where's the council? List tomorrow.
Lordship, with the concern, the other party lordship, like to mention, item 15, your lordship.
1-5.
1-5, lordship, the private respondent number 4 has filed their affidavit, lordship, we have to file a reply to that, your lordship.
It stated that the,
I appear for respondent number 4 in this matter.
Hmm.
There was a short period, there's a status quo operating, so I'll request that a date for final disposal may be fixed.
In the meantime, we'll file a reply, your lordship.
then counsel for the appellant prays for time to file an affidavit in reply to counter the affidavit in opposition filed on behalf of the respondent number 4. The interim order granted earlier shall continue till next date of listing, re-notify on 22nd November.
Lordship, can it be thereafter, lordship, on the next day, lordship, actually, what happened, lordship, the constitution bench is about to be again rescheduled on that week.
All right, 29th November.
Much obliged, lordship.
Obliged.
Much obliged.
Daily list for orders item 7 to 9.
May I please, your lordship?
Yes.
In item number 7, lordship, we have filed one additional affidavit, lordship, regarding management of plastic, lordship.
When did you file it, madam?
On 10th.
Hmm?
29/9/22.
30th September, yes, affidavit is there on behalf of respondent number 8.
Yes, lordship.
Okay. What have you said in the affidavit, madam?
Here regarding the management of plastic, we have stated, lordship, total number of ULBs in the state of Assam, 104, including GMC. And numbers of ULBs under consideration of Swachh Bharat Mission, 96 numbers, lordship, including GMC. Newly constructed ULBs and not under consideration SMBs, lordship, and in Alexa D, lordship. At present, there are 104 ULBs, including GMC in the state of
So
Assam.
we are just reading the affidavit. We
Lordship.
want to know the summary. What are the
Lordship, there is,
steps
lordship,
you
regarding-
propose?
Regarding, lordship, plastic, lordship, we have sending it to cement factory of Umrangso, lordship. 144 numbers of material, recovery facility and this to segregate plastic, lordship.
Okay.
Main is this, lordship, and we are taking steps for ban on single-use plastic, recyclable, reusable plastic by Environment Forest Department and Government of Assam.
Okay.
And the lordship, single-use plastic action has been taken as follows, lordship. State level task force has been.
Is there any proposal to deal with the sanitary landfills and the legacy waste? What has been done for that?
Earlier, lordship, except plastic, lordship, we have filed another affidavit, lordship. There are too many technical statements, lordship. Actually,
So why don't you keep your official present? He can explain better.
lordship,
Okay. When? Keep your officer present, concerned officer. He can explain to
who
us.
can explain, lordship?
Ms. Das,
Lordship.
Hmm.
And
they have shown some steps for the plastics.
Lordship.
What actually is happening on the ground level, we can't say. Anyhow, that's at least the beginning. You would say.
That's true, but this landfill, sanitary landfill, my lord, again, same thing has been followed, my lord. They are creating solid waste management plan, my lord. And that will again generate landfill and whatnot.
That's happening everywhere. Unless they incinerate it, there is no
Incineration is
solution.
the only source.
No solution at all.
Because we have to think of the future.
There's nothing. Yeah. Yeah. Do you have any report regarding the proposal for the solid waste management or disposal rather? Is there anything? Not. Ms. Nayak, are you having any idea?
Lordship, so far as Naga is concerned, Lordship,
Uh,
the project has already been.
But that is simply filling in the landfills.
No, Lordship, it's a solid waste management, it's a complete project, Lord.
What is the sum and substance of that management plan? Tell us.
On last day, Lordship, I was submitting, the tender was already plotted.
What is the idea? How do you plan to deal with it?
That DPR, Lord, one DPR has been prepared by the expert.
Can you tell us the nitty gritties?
If lordship allows me to, or the nature, I just raise that.
Okay, very well.
Yeah, so one officer from Swachh Bharat Mission, Lordship, who can explain better.
Okay, very
than
well. Keep the officers present.
Lordship.
In the affidavit file in item 9, my lord, they have annexed some photographs that will reveal that these are landfills only. And the current affidavit file, they say
What they do is they shift it from one place
to another.
to another, that's all.
That will not be a solution at
There'll
all.
never be a solution. They'll be creating
Be a solution.
mountains and mountains at different locations. That's
Yes,
all.
my lord.
Keep your officer, yes.
I have been, my lord, given a copy of the affidavit. My lord, it gives a rosy picture about policies and, my lord, the ideas. But the problem as it is always implementation.
Yes, that's
Nowhere
right.
it is said that this one has already been started.
So that's why let's call the official concern.
Yeah,
We'll
yes,
ask them. Okay. MS RB Bora shall keep the official concern of the Swachh Bharat Mission present in the court on the next date. Mr. Naik representing the municipal board, MB Nago?
Yes.
MB Nago,
Not municipal board. I mean, I am representing the district at least.
representing the district administration, submits that in Nagaon, there is a project for dealing with the solid waste project for the solid waste management, and the DPR has already been issued. He may keep the official concern present in the court on the next date to explain the manner in which the authorities plan to deal with the solid waste.
Look, on the next day, I'll try to give some documents with regard to this incineration plans. If they can have some idea with regard to that.
Do that, please.
Yes.
Re-notify on 30th November.
Deeply obliged.
Deeply obliged.
Yeah.
Item number 10.
In this case, on the last occasion, central government took a stand that because of non-furnishing of certain materials, further funds could not be released. So I have received instruction on 30th of September, my lord. The principal secretary, Karbi Anglong Autonomous Council, has forwarded all the requisite documents that they have mentioned in their checklist, my lord, to the
Central government?
To the Secretary, Hill Area Development Department. Presently today, my lord, file is with the Additional Chief Secretary, Hill Area Department. They will be forwarding it today or by tomorrow, my lord.
They will be forwarding it to
The Donier, my lord, department.
Donier. Okay.
By at least by tomorrow. They are saying today, by tomorrow they will send, my lord.
बोलो अब क्या करना है? What is to be done? ठीक है, लिखाओ.
Mr. P.M. Goswami, learned additional AG Assam preparing for the PhD department submit that the principal secretary.
Principal Secretary, Karbi Anglong Autonomous Council.
Karbi Anglong Autonomous Council has already forwarded all the requisite papers, which is lying with the office of
Additional Chief Secretary.
Chief Secretary.
Hill Area Department, Government of
Area
Assam.
Department, Government of Assam, and those documents would now be forwarded to the donor ministry within a day or two. On such ground, we learn it additional 6 posting of this matter again after 6 weeks. They are allowed. This case taken on 30th.
My lord, item number 8.
What happened?
They were supposed to, they filed an affidavit to which I have not received the copy.
They filed an affidavit in 9 probably, not in 8. In 8, anyone has?
We have not filed.
No affidavit has been filed.
7 and 9.
7 and 9. Bro, 7. Affidavit has been filed in 7.
No,
You want a copy? You can have a copy of that affidavit. We'll ask Madam Bora.
No,
In
you
8,
said
there is no
for
affidavit.
Shifting, there is a land allotted. That
That instruction hardly occurs in that place before.
There is already given.
Allotted.
I don't know what.
An amount has already been sanctioned. Now.
You have a look at the previous order sheet. Maybe you will find out. Yes, they already give item number 8 once.
এটা কোথায় আপনি ফাইল করেছেন? এইটা ঠিক
retaining wall construction.
Yes.
For sanitary landfill site, setting up of the solid waste management plant of Shivsagar. So they have given basically a project report kind of thing, DPR. That's all they've provided. You need a copy of the DPR. What you will do?
DPR also I haven't received, and actually our case was for shifting of the garbage yard.
So they are preparing a proper landfill management site.
Yes.
That is what the DPR is about. Have a look at the DPR from the file. You got a extra
Yes,
copy.
I
You show it to her.
Yes.
Okay, next.
Item number 11.
Yeah, okay. What is it? Yes.
Look, this is with regard to protection of the
Architectural monuments.
yes, historical monuments.
Yes.
The state was supposed to come up with some detailed projects.
So we had pointed out there was a news report on the last day.
Yes,
We recollect.
My lord, we have already filed an affidavit today, my lord. My lord, this is not a protective site as of now, but the state of Assam will take steps to make it as a protective site, my lord, protection site.
Has it not been done as yet?
My lord?
Has it not been done as yet?
No, my lord, but
Why?
my lord, they will take steps, my lord, to do it, my lord.
Okay, when,
And
in
my-
which file
my lord,
you filed the affidavit in
my-
PIL?
Yes, my lord,
318.
today it has been filed.
Today.
My lord, we have extra copies if required, my lord.
Let's see. Have you provided a copy to Ms. Das?
Yes, just now I have got Yes, I'm just.
What is this IA about?
This affidavit deals with the last order passed by your lordships. That
Regard that
site in-
monolithic site.
Yes, monolithic site.
Yes, yes.
But it doesn't say anything about the other sites.
So other we had implemented the Archaeological Survey of
Yes,
India.
yes.
What is their stand?
Dispose of IA in this. No?
So you need to hasten the process. Please expedite the process. All right. In item number 3, the main writ petition takedown. In response to the directions given by this board on so and so, such and such date, comma, an affidavit has been filed on behalf of the state of Assam, wherein, comma, it is indicated that the site of monoliths, site containing monoliths, which was monoliths, the two historic sites belonging to pre-Ahom era, which were highlighted in the English Daily Assam Tribune, issue dated 25/8/2023, are now proposed to be declared as protected sites, and steps in this regard are under contemplation. We hope and trust that these steps shall be expedited. Now in this impediment, who has filed the impediment?
So far as the other sites are concerned, they will come up with some.
Regarding the other sites, protected sites in the state of Assam, the response of ASI is still awaited. Mr. Mehdi, the Central Government Council, shall complete his instructions and file the requisite affidavit by the next date of listing.
Deeply.
In this IA, all the historical monuments probably have been charted. That is right.
But what my responsible submission is, my lord, Dr. Fukan sir is also here.
Yes.
He was last 2-3 weeks, he was busy with the UNESCO team for showing the historical sites for declaring it as a heritage monument
Okay.
site, my lord.
Okay.
He praised before your lordship.
Can we have the advantage of hearing him?
My lord.
Yes, please.
Yes.
Definitely.
What he says, my lord, that he is preparing a booklet on the collecting all the.
He can enlighten us right now. Please come to the last. Yes.
My lord, kindly allow us for some time for.
No, we will grant you time. We'll accept your implement application. We'll allow you to intervene. But if you want to say something right now, please state so.
Accept the adjournment.
He's already been impleted, yes.
He has already been.
Yes,
He has already been impleted, yes.
This application is by the association.
My lord, there are two organizations and personally Dr. Fukan is there. They collectively, they were collecting the evidence.
Okay, okay.
To support before their lordship, my lord.
Right.
What sincerely we pray, my lord, that one application is not before your lordship, my lord.
We have two applications. One has been allowed.
Yes.
One
This
is by the
one
All
more-
Assam Home Association.
I'm
Yes.
told, my lord, one more application is there, but there is some defect in the filing section. That is what not.
Who has filed that application?
This is, my lord.
You are the counsel.
Yes, I'm-
So all right, you are already assisting the court.
Yes, yes.
There's no difficulty.
No difficulty, my lord. What Dr. Fukan is saying, my lord.
Yes.
He want to produce all the things in a booklet manner.
Very well.
This will help the honorable.
So if he is able to prepare the booklet in advance, let a copy be provided to Learned Advocate General as well as the Standing Council, Government of India.
That will do.
So they will take instructions how more steps, better steps can be taken
Yes.
to protect these monuments.
And his booklet will be consisting of those sites which is not yet covered, but historically important.
Yes, we understand. Dr. Jogendranath Fukan, present in person, submits, who has been implemented who has been allowed to intervene in this proceeding, submits that he is preparing a booklet incorporating therein, all historic sites in Assam, which are still not covered under the protected monuments. We appreciate the efforts of Dr. Fukan. The booklet, upon being prepared, may be copy thereof be provided to Learned Advocate General Mr. Saikia and Mr. S.K. Medi, Standing Council, Government of India, to take necessary instructions so that these sites can also be brought under the purview of protected monuments.
We oblige me.
He is preparing a booklet of sites of Ahom era or all historical sites.
Particularly, basically on the Ahom monuments, my
lord. This association, you have filed the application. IA number so and so seeking implement is disposed of by permitting the applicant to intervene in this matter.
Oblige me. Deeply oblige.
List on 30th.
Item number 12.
Respondent number 6 has filed an affidavit, and to which we would like to file a counter.
Okay. Affidavit on behalf of the respondent number 6 has been filed. Affidavit in opposition has been filed on behalf of the respondent number 6. Then counsel for the petitioner pays for and is granted. Is this supposed to be?
Pardon me?
So your lordship, the service is not complete regarding respondent number 7 to 10. Office note dated 22nd of August.
Hey man, what I was thinking was to take steps for effecting service on the other respondents.
Yes, ma'am.
I was thinking, Uh, Counsel for the petitioner shall also take steps for reflecting service on the unserved respondents number so and so. Within 3 days, rule is made returnable in 6 weeks. Thereafter.
Can you give us a date, my lord?
But you have to get the service effected list on 30th November.
Obliged, Your Honor.
Item number 13.
This is the one which came up from yesterday, na?
Borulu River.
Yes. Okay, that is Barul River.
Lord, as per the last order, my lord, they are to come up with remedial measures to decrease the pollution in the river, my lord.
In the meantime, my lord, affidavit is filed, my lord. A survey was conducted by the test was conducted by the Pollution Control Board. The affidavit has been filed, my lord.
On 10th March, 10th October.
Lord, 10th October.
Yes, my lord.
Yes. What have you said in the affidavit?
Lord, this is too technical, my lord. This affidavit, this.
Lord. But Mr. Das, practically speaking, when we are looking at that area, but seems to be little clean. Earlier it was
Maybe
full of
because of
filth.
the rain, maybe because of the rain and all.
Maybe
Yes.
by their efforts. Why do you rule that out?
No, that's true, my lord. Some initiatives are taken to reduce the gathering of these plastic bottles and
Yes,
all.
yes,
That I also saw. My lord, one thing in this affidavit, page 25, if your lordships kindly take up. One aspect I could go through that BOD level. They have mentioned, my lord, I searched in the internet, I found that 6 to 9.
Dissolved oxygen. No,
Yes.
what is BOD?
Biochemical oxygen demand.
Oxygen demand, yes.
Yes, so it is, if it is in between 6 to 9, it is polluted. Now, if your lordships kindly.
14, 12,
12,
that is
18,
18.
it goes up to 130 down below.
130. My goodness.
So one report prepared by the committee, formulated by the government of Assam, I placed on record before your lordships. That is 24/8/2023. This report contains, my lord, detailed procedures as well as what they have to do, STPs and all.
Should we request the IIT Guwahati to provide us some assistance?
That can be done, my lord, because otherwise, if your lordships kindly consider this report, my lord, very beautiful recommendations are made regarding creation, my lord, erecting of STPs and all. And this report was submitted in 2019. If despite
What
this
have you done about this report?
Ultimately, the STP had to come up, my lord. At three places, the STP had to, at least in 3 places, STP had to.
Has to come out when will you install the STPs?
I'll get the instruction of when they are.
Is it going to take ages?
No,
Then
Lord, will take me some time to get the instruction. Why?
we want your response regarding execution of these suggestions given in this report by the next
This
date.
report is of 2019, my lord.
Mr. Das has drawn the court's attention. An affidavit has been filed on behalf of the
GMC lawsuit.
GMC, respondent number 4 GMC, which indicates that some steps have been taken to alleviate the issues of pollutants falling into the Baralu River. However, as per Mr. Das, the BOD levels of the water samples is alarmingly high at many places. Mr. Das has also drawn the court's attention to the report prepared by
it was prepared by a committee
by
River
Rejuvenation Committee for the report dated 23rd September 19. River Rejuvenation Committee, Baralu River, which is yet to be implemented, and council to take instructions from the authorities concerned regarding implementation of the suggestions given in the said report.
In fact, the irony is that the said report, my lord, para 13, it has action report. It fixed timeline. what to do within what time, and all are 1920.
I will get the instruction.
These are all for, my lord, keeping in the files and nothing else.
Let's see.
Highly appraised.
30th.
Item number 14.
Lord, item number 14 is the Depot bill matter, where two authorities were yet to file their affidavit, the Pollution Control Board and the Water Resource Department. And the most important part is that the Assam government on the last occasion, the learned Advocate General has said that the ESZ is being placed before the cabinet. Now, what happens if they don't take a decision? It is already 2 years. The Central Act, that is these 17 rules cannot come into operation.
That's right.
So that time limit.
What has happened to the ESZ matter?
I'm appearing for the Forest Department. My instructions are that final ground truthing operations are underway in consultation with the GMDA and district revenue authorities. Your Lordship.
Right now, we are asking you a query regarding the eco-sensitive zone.
Yes, Your Lordship. Regarding that, these ground truthing operations, Your Lordship, would be necessary for preparation of the draft proposal, which will be placed before the cabinet. Those processes.
How long will it take? It's 30th August last we met.
Yes, Your Lordship.
So it's been nearly 2 months thereafter.
Yes, Your
1.5 months.
Yes, Your Lordship.
What has happened in that period?
The process, Your Lordship, since between that, it was the Depot bill had also flooded a little, Your Lordship. So because of that, it had slowed down a little, the process, Your Lordship. Now it's again underway. And this is the latest instruction that I have, Your Lordship, that after these operations are complete, the draft proposal will be prepared and placed for the cabinet.
We'll fix a deadline.
Very well.
Because the draft was of 2022. Well, 2 years they have already taken. Now it will go till.
Council, Mr. Pathak, representing the Forest Department, submits that till date, the draft proposal for declaration of the Depot bill as eco-sensitive zone has not been prepared. We feel that the issue has been delayed beyond acceptance without any justification. Thus, we fix a deadline of 22nd November, before which the draft for declaration of Depot bill as eco-sensitive zone shall be placed before the cabinet.
Very well.
The compliance report be submitted for the court's perusal on next date, list on 30th.
The other two authorities, if
The
they don't give, we will proceed.
affidavits of the Pollution Control Board and
Water
Resource Department have still not been received. The same shall also be filed positively by the next date of listing.
Supplementary list 22.
This Shivamosa PL has been registered, my lord, on the basis of a letter issued by some villagers, my lord, saying that, my lord, due to operation of two mines, my lord, there are ecological imbalances have been caused. I have received instruction, my lord, today itself, my lord. My difficulty was that, my lord, after the issuance of notice of motion, my lord, I was expecting copy from the registry. I could have also obtained, my lord. So day before yesterday, I communicated to the DFO, my lord. This is the instruction, my lord. They say there are two query, my lord, the mining lease, my lord. There is only one lease, my lord. That has ended on 23rd of May 2023. And my lord, it peruses the letter of the villagers. It is dated 9th of May 2023. 9th of May, they wrote a letter to your lordship, my lord. Then this lease came to an end on 23rd of May 2020. Then thereafter, no lease.
There is no operation thereafter. What do you say?
Actually, I'm appearing on behalf of Mr. PJ Monto.
Okay, he is a standing counsel.
Yes, Lordship.
All right, you file this one affidavit.
I will file it.
Mr. Goswami appearing on behalf of the mining department.
All the
respondents. Praise foreign is granted. 3 weeks, 6 weeks time to file affidavit in opposition. List on 30th November.
Obliged.
Top of the list matter, item 1 to 3.
These matters, the two maps, one prepared by this, that those are supposed to be reconciled. My latest instruction in that process is not complete. Lordship may fix a time frame in this matter also, Lordship. Then perhaps they'll be moved to action, Your Lordship.
Look, this matter is with regard to the protection of the
Amsang
Amsang Wildlife
Amsang
Sanctuary. my lord.
Wildlife.
Rampant encroachments are there, my lord, there is no doubt about it. This honorable court entrusted the responsibility to the Survey of India to demarcate the area. Survey of India, my lord, in the year 2021 submitted the report that this is the area. Forest Department said, no, there are some discrepancy with our map. They want to reconcile it. Now to 2021 to 23, my lord.
2 years.
Reconciliation.
The forest department is interested in getting the encroachments increased or what?
Lordship, what the difficulties that we are facing, Your Lordship, is just to bring the ground reality to Your Lordship's attention. That apart from those illegal encroachments, the new maps that have been prepared by the Survey of India, within that, when some portions of the army cantonment, the BSF camps.
All right, you reconcile
Yes,
and come out
that-
with the correct
Your
map.
Lordship, may fix a time frame, Your Lordship. We'll do it, Your Lordship.
The central issue in this recreation, in this PIL, pertaining to removal of encroachment from the Amsang Forest Reserve. Mr. A.P. Pathak, appearing for the Forest Department, submit that the process of reconciliation of different map was to chart out the area of operation is still under progress and will be completed within 6 weeks from today.
Lordship, it may not be placed from my mouth, Your
Still under
Lordship.
progress.
Lordship will fix a deadline.
Full stop. However, from the records, we find that several adjournments have already been granted on the same ground. As such, we make it clear that whatever process is being initiated for preparation of generation of correct map in consultation with the various stakeholders, be completed and be finalized on or before. On or before 15th of December. 2022. Let this matter be discussed again on 21st of December.
My lord.
Deeply.
Yes,
Your Lordship was pleased to take it along with the Amsang.
Which one, which one?
Item 1.
Hmm.
They also let them produce the action taken report.
All right. Item number 1, action.
Action taken report be placed on record in item on the request of Mr. K.P. Pathak, Learned Council representing the Forest Department, Assam, this matter be lifted up again on 15th of December. No, sorry, 21st of December.
20.
So as to enable the Learned Department Council to place action taken on record.
Highly observed.
Item 4 and 5.
This PID is against the earth cutting, lordship, the illegal tree cuttings, your lordship, and there are, and in occasions, lordship, there are also steps, there are also newspaper reports, lordship, where it has been shown that lots of lordship timber logs has been disappeared from the forest department, from godowns, lordship. Against that.
This matter, Your Lordship, some of the forests that are alleged to be under encroachment. On the last, we had filed an affidavit, Your Lordship, where there are some boundary disputes, Your Lordship is aware, between the neighboring states. So Your Lordship had directed us to serve copies of the petition to the
Other states.
So we have served copies, Your Lordship.
Other states reply.
As far as Mizoram is concerned, I have received the additional affidavit.
That is the report, Your Lordship.
That is the report.
That is the report.
That was served to our office, Lordship, like without the order, we didn't see the order at that point of time. So I got to know about this a couple of days back, so I need some time to respond.
Lordship, direction was to serve the affidavit because the affidavit contains a detailed report where which forest area, how much is under encroachment by which, allegedly under encroachment by which state, Your Lordship.
You have to provide the report is incorporated in the
It
affidavit.
is there, Your Lordship.
Okay.
The detailed report is there.
You filed an affidavit when?
This
18th May.
18/5/2023.
They've got a copy later. That's
We have break for the copy of the PIL. also.
Copy PIL.
That
Give
will
a copy
be
of the
Provide-
PIL
so
also.
We'll provide the PIL as well. As well as the affidavit reply also.
Learned State Council appearing for the state of Mizoram, Arunachal Pradesh and Nagaland submit that due to want of complete papers in connection with this proceeding, the affidavit could not be filed. As such, the Learned State Council have prayed for 6 weeks further time to file affidavit. It will furnish them with the copies of the PIL and the affidavits filed by the
PILs, right? Oh, no.
both the PILs and as well as the pleadings filed these proceedings. In view of the above, register to provide the requisite papers to the learned counsel representing the three states. Let this matter be lifted again on 30th of November. Affidavit is brought. Reading affidavit be brought on record on 11/2020.
Item number 6.
Lordship directed AUIIP to file its affidavit. Lordship, I filed my affidavit yesterday. Let the affidavit be what on record.
Affidavit is there.
Affidavit is not, check the record. Affidavit has not been on the record.
Today they filed us. Today. Actually, Mr. Bora, these affidavits are coming.
Lordship.
You are showing things in bits and pieces. You've seen it. But please tell us, what is happening? Are you supplying water to the residents of Guwahati city?
Some parts there we are supplying it, my lord.
Which part you are supplying?
And
Water supply is operating in which parts?
Jal board is supplying that area. Under Jal board is supplying, my lord. They're supplying the water to those who have applied. In fact, we are facing now problem is that nobody is applying for taking that water.
Oh.
That's the problem we are facing because all have a deep well. They are using the deep well. Now,
But just
at the
a
same
minute.
time,
Jal board is now providing the water supply.
following the water supply.
Entire Guwahati?
Not entire Guwahati.
Then
Because
which
they are phase wise different. At a GMDA, the construction is going on of pipelining. It will take up to December 2024, as well as this association, which is supplying, which is for construction for the area called South Guwahati Water. That will take some time, my lord. My affidavit says it will take up to December 2029.
And where is the Jal board now operating? Which
Jal
area?
board area, Jew area, this Jew area it is operating, as well as Bhaga area it is operating. Even my area also, I am living in Bhaga, that water is available, my lord.
Dispur area, Dispur?
Dispur already there is in the Dispur area, some parts already there is water by earlier GMC, my lord. It will be shifted to Jal board. Entire Guwahati will be taken over by Jal board. After GMDA completes everything, it will be shifted to Jal board, and subsequently all the area Guwahati will be entrusted to Jal board because by Act Jal board has come up.
So this tender process is now pertaining to work to be carried out under the GMDA.
GMDA work is going on. It will take up to December 2024 to complete the entire work. Area which is under.
Will be set up by them, then operations will be given. to the
Operation will shift it to Jal board. Already GMC is supplying, that will also be shifted to, GMC will not supply anymore after it is been shifted to Jal.
So everything will be handled by Jal board.
Everything will be handled by Jal board, madam. Even we are connecting is, then giving tenders for connection. For that also there is petition pending, and there is one stay for one of the supplier for giving connection, madam. There is one petition pending where stay has been granted. Let it come on record, my lord, this affidavit, my lord.
All right. Affidavit has been filed on behalf of GMDA.
No,
GMC.
No, AUIIP, that is Assam Urban Infrastructure.
By current government council, Mr. Bora, the same be brought on record. List on 30th November.
Also, can it be on 9th of November, Lord?
There is a specific date for these matters. 30th November.
Supplementary list, item number 16.
Lordship, there is an eyewitness here. In
Is the
fact,
council?
council is not here. In fact,
Amicus.
Mr. NJ Das, I know him. Today he must have missed, I don't know, but.
Oh, the brother is there. That shopkeeper.
That
Shopkeeper is there.
That, yes, Ambika was there.
Burman.
And,
Burman, yes.
he saw it. And others have seen him running away from the place of occurrence. And bloodstained dove was also there. There's an FSL report.
Now what? Was it recovered at the instance of the accused?
No, not 27 recovery, but then the blood was found to be of the same group as the blood in the place of occurrence.
Who says that it was the same dove?
Same
Who
dove
says
is
it?
again
Then
difficult.
But then the blood found in the place of occurrence and in the dhow are same.
The fact that the deceased was murdered by the dhow, there is no dispute. But whether it was the same dhow, whether the accused possessed it, there is no evidence to that effect.
Coupled with the eyewitnesses account, perhaps that will have some effect.
If the eyewitness is reliable, do you need to corroborate by recovery?
No, not
Then-
not required. Or one witness would be enough.
Then
And it is not demolished also in her cross-examination and all. 164 is also there. He had said the same thing.
at 164,
Now,
is it
Ambika's
a
164.
substantive
No,
evidence?
only to corroborate the main.
It can't be even used for corroboration.
But sometimes
Only for
164 contradiction and corroboration, it is said. 161 only contradiction. I have a few judgments on this. But
None
otherwise,
present for the appellant.
Lordship.
The amicus curiae appointed to assist the appellant in this case is not present. Re-notify after 2 weeks.
2 weeks.
Item number 17.
Matters. Interesting pieces.
Please, your lordship.
My lord,
The wife and the daughter is there. Oh, the husband and the daughter.
Yes.
my lord, this appeal has been prepared against the judgment dated 18 February 2017, passed by the learned session judge, Gulagar, in which I was being convicted for life under section 302 and under section 448 for 2 months and under section 324 for 6 months.
Yes.
Well, this, I would like to take your lordship before I go into the nitty-gritties of the matter.
There's an injured eyewitness,
daughter
then there's
is
a
there.
daughter.
Daughter.
My lord, the first and foremost thing was that if we look into this, there has to be an FIR. In this case, the learned trial court did a fundamental mistake by relying upon an Azahar, which was in fact hit by 162. It was the GD entry. My lord, your lordship will see. My lord, I will go with one by one. First, your lordship kindly come to the FIR at page 4, Azahar at page 4. Our humble submission is that around 6 p.m. yesterday, that is on 38/14, the aforementioned accused persons went to the house of my elder brother, Sri Bogai Gogoi, and entered the house by breaking the door and severely assaulted Bogai Gogoi by hacking with a dao. Sri Bogai Gogoi came hurriedly to my home in injured condition and informed me about the incident. It is worth mentioning that after Bogai Gogoi fleeing away from the house with an apprehension of being attacked by the accused, when his wife Faguni Gogoi was running away from her house, the accused seized her from behind and hacked her with a dao, thereby causing grievous injury to her. When the accused again came to Bogai Gogoi's house and searched for his daughter, Podumini Gogoi, protected herself by fleeing from that place after breaking the wall of their house. Severely injured Bogai Gogoi and his wife, Faguni Gogoi, are admitted in very serious condition. It is therefore prayed to the humble sir to take necessary action upon investigation of the matter. Now, in pursuance to this FIR, Azahar, the PS registered the case under section 448, 326, and 427 IPC. Now, I surrendered before the court. Now, what happened, your lordship? The charge sheet was filed. Charges were framed against me under section 302, 324, and 448 by order dated 5/6/2015. And to substantiate the prosecution case, prosecution examined 14 numbers of witness. Now, your lordship will kindly see come to evidence of PW1,
Yes.
who happens to be the complainant.
Yes.
At page 9, I know the accused. The accused is our co-villager. I am the complainant of this case. This is Faguni Gogoi, alias Fesu is my sister-in-law. Injured Bogai Gogoi is my elder brother. The incident took place on a summer evening last year. The incident first took place at injured Bogai Gogoi's house.
He is not an eyewitness.
He is not
What do you want to say from his evidence?
Your Lordship, what he even denied, he even accept the content and veracity with respect to the Ajahar. Your Lordship will kindly see at page 10. Page 10.
Yes.
I lost exhibit 1 3 days after the incident. I cannot say who wrote exhibit 1. I put my signature in it as people asked me to do so.
Yes.
My lord.
He is otherwise not an eyewitness of the incident.
Eyewitness.
Yes.
And second thing, your lordship, the main thrust of this prosecution case was on the basis of two witnesses. That is the victim, that is the father, and the daughter, which the court, learned trial court took it as an eyewitness.
Yes.
Now, your lordship will come
Criticize
to
their evidence.
Pardon, my lord?
Criticize their evidence.
My lord, your lordship will kindly come to evidence of PW4, that is the father.
First read PW3.
My lord. Oh, my lord, yes.
Yes. Padumi Gogoi.
Padumi Gogoi. I know the page 13. I know the accused. The complainant is my uncle, and the deceased is my mother. The incident took place one evening about 1 year ago. At the time of incident, my deceased mother and I were cooking rice. My father entered inside the house after taking bath. Just at that time, the accused entered inside by kicking the door and hacked my father with a dowel. Hearing the sound of kicking the door as my mother and I were coming out, I saw the accused was hacking my father. In order to come outside from the kitchen, we have to cross the room where my father was hacked.
Just hold on, Mr. Record the original. Where is the LCR? Okay, carry on. Yes.
In order to come outside from the kitchen, we have to cross the room where my father was hacked. Seeing my mother and me, the accused chased us in order to assault, and then we fled through the rear door towards the house of our grandmother, Thaneswari.
Yes.
On the way, near the bank of a stream, the accused hacked my mother on her left shoulder with a dowel. I rushed to inform my aunt, wife of my father's younger brother, about the incident, and coming back, I saw that the accused was still hacking my mother. My aunt, her children, and I started shouting, but none of our co-villagers came out. When my father informed our village headman, the village headman and other people came to the place where my mother was hacked. Thereafter, a 108 ambulance was called, and my mother, along with my father, were taken to Sorupatar Hospital. Thereafter, my mother was taken to Golagat Hospital, but as the hospital did not take her in, she was taken to Jorat Hospital, and she underwent treatment there for 3 days. From there, she was shifted to Dibrugarh Medical College and Hospital. After undergoing treatment there for 6 to 7 days, my mother was brought home as she didn't recover there and also because of a poor financial condition. Around 7:30 p.m. on the following day of a return.
Yes.
Around 7:30 p.m. on the following day of a return from the hospital, my mother breathed her last. My father was also treated in Jorhat. I saw cut injuries in head, abdomen, hand, and waist of my mother. Police got my statement recorded in the court. Exhibit 3 is the statement, and Exhibit 3.1 and 3.2 are my signatures therein. That is the 164 statement. At the time in the cross-examination, at the time of the incident, I was studying in class 8. I go to school by residing at my maternal uncle's house. My maternal uncle's house is about 1 kilometer away from our house. My maternal uncle's name is Ghonokanto Chutia. Our house consists of 3 rooms, including the kitchen. I cannot remember the day and date of the incident. The incident took place around 6:30 p.m. It was getting dark at that time. At the time of the incident, lamp was light only in the kitchen. My grandmother Thaneswari had died before the incident. On the day of the incident, people gathered at my paternal uncle Prasanto Gogoi's house, as it was the day of my grandmother's Sardha ceremony. I did not go there. My father was with the people at my paternal uncle's house place. It takes 3 minutes if we go to Prasanta uncle's house on foot. It is not a fact that I did not state before police that kicking the door of our house, the accused had entered inside our house and hacked my father with a dowel. It is not a fact that I did not state before police that hearing the sound of kicking, when my mother and I were coming outside, I saw the accused hacking my father. It is not a fact that I have falsely stated that the accused had chased me and my mother and hacked my mother in her left shoulder with a dowel on the bank of a stream, and that when I returned after informing my aunt about the incident, I saw that the accused had still been hacking my mother. It is not a fact that I have stated falsely that my aunt and I raised a hue and cry. It is not a fact that I had not seen any mark of injury on my mother's person. It is not a fact that my mother died from some other ailments due to lack of treatment. It is not a fact that I was not at home at the time of the incident. It takes 4 minutes to...
No. Yes.
It takes
just a minute.
Yes.
It takes...
What are you trying to get from the cross-examination?
My lord, the main thrust in the cross-examination was that there are 2 thrusts. One was to try to demolish the matter by putting those suggestions, and second one was that which I think was that to prove that there was a blood between these 2 families. Regarding one thing was that regarding that money
wanted to marry the girl. They had taken accused wanted to marry the girl.
My lord,
they had taken 20,000 rupees.
My lord.
Who had the motive then?
My lord, that has been what I was trying.
That is your suggestion.
My lord.
So that proves counterproductive. You have a motive now. 20,000 rupees taken, girl not given. All right, face the brunt of it.
Well, in a cross-examination, what they have tried, what I try to understand, Your lordship.
That is harakiri.
Pardon?
That is harakiri in Japanese. The pilots used to just crash their airplanes in the enemy base. So that is harakiri. Yes, kamikaze. Yes.
Lanet, in the trial court, what my friend might have tried to do was that if we go on a little bit, let me take.
We have read the entire statement. What you want to focus, tell us.
Well, what was the thing was that what my argument is here, your lordship. This evidence, this witness
cannot be taken as a fact that has been proved under section 3 of the Evidence Act. Your Lordship, I will take one by one step. Second thing was that the learned trial court relied upon the evidence of his father. Besides this, the father, Your Lordship, a victim who says, for example, I will give an illustration. A person says that X has assaulted me, but in his deposition, he does not name. How can a person, he will run away? Your Lordship will see the evidence of.
He was a coward. He was a coward. He ran away. What of that?
But even in evidence.
Yes.
Even in evidence, Your Lordship.
Yes.
I know the accused person. The deceased was my wife. The informant is my younger brother.
Yes.
The incident took place about 1 year ago during the time of planting paddy sapling. The incident took place in the evening. After
Yes.
taking bath, as I was entering inside my house.
So the accused was present in the court. He has identified him.
No, he is not identified.
He was present in the court.
I was present.
He says, accused, I know the accused. That is identification.
My lord, someone hacked me with a dowel. Someone hacked me with a dowel in the right side above my waist. The palm of my left hand got cut. Then I started shouting. Your Lordship, if Your Lordship wants to take the view that I know the accused person because we are resident of that place and I'm an accused. But he has not stated that this is the person who was present in the dock. He is the person who assaulted me.
Yes.
Then I started shouting. At that time, the deceased and my daughter Padumi were busy cooking rice in the kitchen.
It is very tempting. Yes.
Thereafter, I fled to the informant house to protect myself. Thereafter, I went to our village headman Yadav's house and informed him about the incident. I also told the informant about the incident. The person who hacked me also hacked my wife on the bank of the stream. The village headman's house and my house. Thereafter, the deceased and I were taken to Sorupata Hospital by a 108 ambulance. Thereafter, we shifted to Golagat Hospital. At last, the deceased was admitted to Assam Medical College, Dibrugarh. Since the deceased was not recovered there, she was taken back home. Around 7:30 AM, the deceased died. Later on, I came to know.
Forget about this statement. What about the child statement? You are not able to get beyond that.
My lord, child statement, if Your Lordship, subject to my understanding, Your Lordship,
yes.
If we see the simple grammatical way,
yes,
she says that she saw the accused, she saw me hacking her father.
Mother also.
Mother also. Now, Your Lordship is there's getting of judgment which says that child witness evidence.
Child means she's not a child within the meaning of that
She is
criteria.
16, as per
She's
JJ
16,
As
yes.
per JJ, she is a child. But
That's
as far as
okay.
be that so. Now that witness says that she saw the accused me hacking her father.
Yes.
Let us go one by one. Your Lordship, let us see the injury report of the father.
Yes.
Simple injury.
So what?
My lord.
What of that?
No, what I'm saying.
So hacking means the hand should have been chopped off or what?
No, my lord.
Then
let me read it again. I saw that the accused was hacking my father.
Yes.
In order to come outside, we have to cross the room where my father was hacked. Now, Your Lordship will see the injury report which says it was a simple cut injury.
So it was a cut injury.
It was a cut
That's what she wanted to convey, that she was using a sharp weapon that is used for hacking simple villagers, rustic girl.
Not rustic girls, but if Your Lordship will see that what I'm.
She will not have a wisdom like Mr. Borogai. Yes. So you're not getting past the evidence of that girl. You have read the file. Any other argument?
My lord, as far as
My argument is that, Your Lordship, if we see the impugned judgment, Your Lordship may kindly come to the impugned judgment. At para 21.
Yes. Yes.
Fact of the prosecution case remains that the occurrence initially was started with injured Bogai Gogoi in his dwelling house and ended in the bank of a stream. The prosecution has examined the state Bogai Gogoi as PW4. His statement under 161 of the CRPC was recorded on the night of occurrence. Your Lordship, the learned trial court relies upon the statement of 161.
There is no statement as such. Is it on record? If you wanted to rely upon that statement so as to use it for just disbelieving or discarding the FIR, then you are required to bring that statement on record.
But I have not done that.
So then
The
there's
accused
no
has not-
statement.
The accused has
It's
not-
all in realm of in the imagination.
No, what I'm saying is the learned trial court did it.
Doesn't matter. 386, we can reverse those findings.
But as far as that earlier judgment which your lordship was referring, that Mohit Vijay.
There is no statement under 161, sir.
What the learned trial court did. Learned trial court said
386.
each statement under 161.
386-4. Read 386 CRPC.
86-4.
Three 86 subclause
B.
B.
Revise the finding and sentence and acquit or discharge the accused or order him to be retried by a
Yes.
court of competent jurisdiction.
B2.
Alter the finding, maintaining the sentence.
So the findings are not binding on us. Even in your appeal, we can alter the findings.
Well, that's the power of the appellate court.
Yes.
That's the power of the
There is
appellate.
a well-defined power in 386.
My lord.
These findings will not just bother us even for a moment. Is there anything else for you to argue? You are missing the bus by a long mile. Come better prepared.
My lord.
Till now, you are not argued the point which is really required to be highlighted. And we are not telling you that. Burn some midnight oil. Yes, paid list of 2 weeks. Yes.
Contradiction.
Item number 18,
Contradiction.
item 18 and 19.
Lordship.
In fact,
Yes.
If lordship permits, can item 19 be taken first, lordship, because that is of 302.
Yes.
18.
Okay.
in fact, there are 8 accused persons here, 8
But
applicants.
in this case, we want to ask a question.
Lordship.
You know, trial court notes in the judgment that there are few accused absconding. What has happened to those accused? The trial court doesn't put a remark at the end of the judgment that the record will have to be preserved. That when, as and when those accused are charge sheeted, their trial will have to take place.
They'll have to.
Nothing.
Those are not.
Look at this. Page 3. Page 3. Page 3. So the trial court has to. The understand. Record name and the appeal may be filed, may not. But appeal file may not. Exam record style. Yeah, page 3 देखिए. Page 3 of the judgment. Judgment.
May I please, your lordship?
Oh, a judgment. What about?
Yes.
FIR was filed.
What has happened to those absconding accused? Do you have any idea?
All on the FIR was filed against 10 persons and subsequently charge sheet was filed against 11 persons.
Yes.
Out of those 11 lordship, 2 are juvenile and
We are asking you, Mr. Counsel, what has happened to the accused qua whom the investigation was kept pending because they were absconding?
but all of them were convicted, lordship.
All of them?
Yes, lordship.
Come to page 3 of the judgment. They were subsequently arrested. Sanatan Mandal, very Sanatan Mandal.
Sanatan Mandal died.
expired during
He
the
died.
trial.
Montu Mandal,
Montu Mandal, he is juvenile.
juvenile.
Tapas
Okay.
and Montu.
Kanmai Mandal. Kanmai Mandal is tried. Okay. Babarani Mandal, he is tried.
Huh.
Halu Mandal, he is
Halu
also
Mandal-
tried.
Right.
Okay. Yes, subsequently they must have been arrested.
Because
Okay.
charge sheet was filed, at that time, most probably these ladies, because 3 of them are women, Lordship.
Okay. Yes.
And the incident occurred, date of occurrence is of 28/2004 at around 3:30 PM, Lordship. And petitioner appellants were convicted under section 323 for 1 year and for 2 years under section 148. And these 2 appellants were convicted under section 149 of 302 for life sentence. Out of those 2 appellants, 1 has expired, Lordship.
Who has expired?
Sri Gordas, no. Sana expired during trial, but
Gosai, Kunadar,
Gordas Mandal. I'm taking item number 19, Lordship.
19. So have we got the verification from the jail? That verification has come from the jail. He must have been in the prison.
No.
He was in,
Due to his deteriorating health.
he was granted bail.
Yeah, due to his deteriorating.
Then the verification has to come from the SHO concerned.
Because landed chief at that time, his person brought him on personal in this court, Lord.
Give the file.
Due to
The verification report has to come from the SHO concerned. Thereafter, the appeal will abate. Then counsel for the appellant states that the appellant counsel, Mr. Sohn, states that the appellant Gordas Mandal has expired during pendency of this appeal. Then public prosecutor shall seek the verification of this statement from the SHO concerned. List on after 2 weeks. Get the verification done.
Yes.
Thereafter, there has to be a formal order of abating the appeal to his extent.
Gotcha.
Much obliged.
Item 20.
Where the wife has been alleged to have.
Paramore and the wife,
Yeah,
but he has not filed any appeal.
No, that appeal it's not there. Well, we'll have to check it in the website. We can.
No evidence.
Matalib, I've tried to check in the website. I didn't get. Registry can find out if there is.
In this case, we find from the trial court judgment that 2 accused, namely Abdul Muttalib and the appellant herein, were both convicted and sentenced to life for the offense under section 302 IPC. However, the appellant has forwarded the appeal from jail. However, there is no appeal on behalf of the other accused, Abdul Muttalib. The full-time secretary DLSA, Nagaon, shall make an inquiry. He must be in which jail now?
Must be in the jail.
Which jail?
This one is. This one is Nagaon. Nagaon.
There is a shall
District jail, perhaps.
shall make an inquiry from the Nagaon Central Jail and find out whether the said accused has preferred an appeal or not. Because in the event of the appeal not having been preferred, the full-time secretary shall provide assistance to the accused Abdul Muttalib for filing an appeal against the impugned judgment.
No, central jail, central jail.
Convicts must not be kept in the district jail.
Central jail, it is central jail, last page of the paper book. Lordship will find last page of the paper book.
Only.
Parvina is in central jail.
Okay. So let's give him an opportunity also.
Lordship, yes.
Yes. The report of the full-time secretary, DLSA, shall be placed for the court's perusal on the next date, list after 3 weeks.
Not.
Item number 21.
21, I think there is an additional evidence.
Additional evidence.
Yes, madam.
this court was pleased to direct the trial court to take additional evidence of.
That has already been recorded. It has come.
It has come. I humbly pray that copy may be given to me.
No, this is not the additional evidence. This is the judgment. We don't know.
As per office note dated 28/9/2021, it came back.
It has come back.
Yes.
All right.
Where's the pink file? I don't know, it's putting flag.
A perusal of the office note. Which is the order? Order 391?
Order dated 4/3/2021.
21.
Yes, madam.
Okay. Appeal against acquittal.
Yes, madam.
Appeal against acquittal.
You are for the complainant?
I am for the information. Yes, madam.
Okay.
He is appearing only for two accused persons. Oh, yes.
Okay. The additional evidence in terms of the order dated 4/3/21 has been recorded by the trial court. The original record has been received back. The statements of the witnesses recorded, whose evidence has been recorded pursuant to the direction of this court, copy of the statements shall be translated and provided to learned counsel for the appellant,
I am appearing
as well as the counsel for the accused respondent. List after 3 weeks.
Obliged.